Judgment.
Item number 1.
Accordingly, FA number 127 or 2024 is dismissed on contest, thereby affirming the impugned judgment. All the three appeals actually are dismissed for default.
I'm deeply
Consequentially, the cans are also dismissed. Interim orders stand vacated, no orders to post.
I'm deeply obliged.
For judgment, item number 4.
Accordingly, FMAT 56 of 2026 is allowed on contest, thereby setting aside the impugned order bearing order number such and such. Consequentially, any subsequent order of extension of the impugned ad interim order if passed stands hereby recalled. We, however, make it clear that the observations made in the judgment are tentative, arrived at only for the purpose of deciding the present appeal arising from an ex parte ad interim injunction and shall not have any binding effect at any further stage of the injunction application or the suit. The trial judge will be at liberty to decide the injunction application and the suit independently without being influenced in accordance with law. It is expected that in view of the pendency of the matter for quite some time, the learned trial judge shall dispose of the temporary injunction application as expeditiously as possible, preferably within 6 weeks from the date of communication of this order to the trial court or the date of filing of written objection by the defendant number 1 appellant, whichever is later. Defendant number 1 appellant shall file its written objection to the injunction application in the trial court at the earliest, latest within a fortnight from date, if not already filed, can dispose of no orders to pass urgency. See, we are not including any matter today. There is an adverse adverse order resolution, so we can't add matters on the one hand and not take up the matters. So when there is no adverse order, then come. Yes, call on the receipt.
This is not the for inclusion.
Then for what?
Item number 103 is a long pending matter. Large number of petitioners are involved. You have already fixed the matter as specially fixed. Matter was hard as specially fixed because of the fact the KMD was dissolved. You have
without certified copy.
Yes, leave is granted.
Subject to your lordship sanction, your lordship last occasion, last 2 occasion I
Call on the list, please.
I beg to appear for the appellant. Your lordship would kindly take, madam, to the. I beg to appear for the respondent. Lord, this is that matter, Lord, the ashram matter.
Auditors,
Just appointment of the names, Lord. Lord, Lord, may I hand up my copy? You want the copy here? Lord, I have a suggestion, Lord, subject to what falls from your lordship. Lord, one from my side and one from Mr. Bhattacharya's side.
What was this for the purpose of? Just remind us.
Naming the auditors.
No, the auditor for what purpose?
The auditor for Lord.
Your lordship would kindly peruse
Order dated?
paragraph 22 onwards.
Which order?
Order dated July 27, 2026. Paragraph 22 onwards, Your Lordship. And 24, my lord has also.
By the impugned order, what was done?
My lord,
Injunction was granted with respect to, my lord, staying the operation of the amended trust deed and, my lord, the new appointed deed. My lord, only modified it and granted injunction, my lord, that the new removal and appointment will not be made, and, my lord, the trust properties will not be dealt with. In addition to that, my lord, your lordship also observed that an auditor is required for the management of accounts because, my lord, cash inflows and outflows are there. My lord, that's why this audit is required. So, my lord, two of our only today was meant for purpose, my lord, that the names of the auditors will be finalized. Lord, my suggestion, subject to what falls from your lordship, is one from my side and one from Mr.
That you have
Bhattacharya's
said
side.
many times.
That-
yeah, Bhattacharya.
Yes.
You have given one name.
I have given two names.
One
My
from,
then a senior friend has given one.
my lord, we have other names also, my lord. So one from our side, one from their side, my lord.
So you are disposing of the appeal with that?
Yes, ma'am.
Yes. That's what.
এটা একটাই দিয়েছে।
হ্যাঁ, এটা একটা দিয়েছে, ওটা
Sanjay Kumar Ringsia, my lord, would be preferable from our side.
You have given two names.
Yes, my lord. Sanjay Kumar Ringsia, my lord, will be
But
preferable.
you have preference.
We have given two names, my lord. One name from his side, one name from my side. So, my lord, from
Why
my
do you
side.
prefer Mr. Rings here?
Lord, Mr. Alok Kumar Bhattacharya, I am told, my lord, is an older person, my lord.
Then delete the name of Mr. Bhattacharya and put a signature there. Whoever is your advocate.
কেটে দাও ফার্স্ট নামটা কেটে পাশে সাইন করে দাও
এই আমাদেরটা তুমি সই করেছো?
একবারটা অর্ডারটা চোখে দেখে নি দাঁড়া টেম্পোরারি নিয়ে এসে
নিচে ডেটটা
ad interim was passed. Main injunction is still pending. You are for the plaintiff
Lord, I am for the plaintiff.
respondent.
Section 92.
Respondent here.
Fine.
So you have to file a written objection there.
No, my
Trial court.
lord, injunction has been disposed of on contest, my lord.
Oh, acha, yeah, right. So very well. So that is continued subject to these people.
No, my lord,
Yes, I'm sorry.
my lord had modified that injunction order. Let that be enforced, my lord.
What was the last modified order?
My lord,
The-
modified order, my lord will find.
87 জুলাই এর আগেরটা
So we said in paragraph 18 of the on the last occasion that unless the impugned order is sustained, you may be permitted to unilaterally change the entire basic structure as contemplated in the original trust deed. Page 18 of the July 7, 2027 order. We had recorded that was at the final stage. Only postpone it for the auditor.
আগেরটা দিয়েছে পেয়েছি পাকাছি প্রথম ফার্স্ট অর্ডার ফার্স্ট অর্ডারের ইনজাংশন এটা ফার্স্ট অর্ডার তাহলে সেকেন্ড অর্ডার
Will appoint these persons, will modify the impugned order to the extent that these persons will now conduct the functioning of the trust
My
property.
lord, the learned trial court has injuncted
But,
me from.
I'll just indicate. Lord, kindly takes up the order dated 5th of May 2026. Lord, paragraph number, Lord, 8. Your lordship had indicated
My lord, paragraph number 8.
there shall be stay of.
We have it.
This was the injunction granted by me.
5th May. 5th May.
Paragraph number 8, my lord, has modified that, my lord. Let that be enforced, my lord.
Hey,
Lordship will not.
কি হলো অর্ডার থাকছে না কেন ফটোকপি একের পর এক দেখছি এটা সেকেন্ড অকেশন হচ্ছে কিন্তু আপনার
Paragraph 8, paragraph 8.
So now who is at the helm of affairs? You. But then you will then continue to do, then how can we appoint the auditors? But this was the initial interim order. But in the 27th July order, we had recorded that we had finally dealt with it. And in paragraph 18, we had observed that in the event the impugned or the previous paragraph is secondly serious allegations of defalcation also against you. Although that does not mean that you are actually guilty of those. But in the event the impugned order is not sustained, the appellant number 1 would be permitted to unilaterally change. How can you and the auditors together function?
My lord,
You have been restrained from functioning as
but my lord would kindly say the interim, the order impugned, the
that
order
has made
impugned,
absolute, yes.
the order impugned, my lord, grants final relief, kindly takes the ordering portion, the ad interim order of injunction.
Yes, where is that ad interim order of injunction, which has been made absolute? Well, you must have annexed that somewhere.
Yes, your lordship would kindly takes 29 January. Yes, my lord. You have to give me this data. 29 January. 29th of January is the impugned order. And the ordering portion, my lord will find that the page 9, internal
No,
page.
no, the ad interim order which was
Hello.
made absolute.
The-
That also we also have with us. That should have been annexed. That is the order which was made absolute. So that is the substantive order.
Page 102 is one sir.
So none of you will be there, Mr. Banerjee. Just the auditors take over. And this will be subject to the
But my
outcome
lord,
of the
on
suit and
on the
whatever
earlier
other
occasion, my lord had also observed that third party would not be introduced.
that will retain.
Third party, my lord, if I am not there, my learned friend's client would not be not there.
That
then-
was the ad interim order. We passed an ad interim order. This the 27th July was the final order. We were going to pass an order. Then this auditor question popped up, and we directed you to requested you to hand over names of auditors. We have categorically observed in the this was the final stage of the hearing.
Yes, but
That was at the ad interim stage before they were there.
but difficulty is this, my lord.
No
that
difficulty.
third
How
party-
can you and the auditors function together? You will create hindrance in every step.
My lord, the auditors let them come up
No,
with
there
the
are
account.
serious allegations against you, Mr. Banerjee.
But the order impugned, my lord, before the learned trial court, my lord, grants final relief. What was his final?
No, that is not always a valid objection. Often injunctions, final injunction which is sought is given at this stage.
And at this stage, my lord,
This will
and
be subject
as
to
on
the
the earlier occasion also observed that, my lord, if the final relief is given, my lord,
You are repeating the same thing, Mr. Banerjee. That was at the ad interim stage. We discussed it finally in the 27th July order. We have specifically observed serious allegations of defalcation and management against you. And why should you exclusively be permitted to run? There's a debate about whether you should be there.
my lord, under the trust deed, it is the admitted position that I am the lifetime trustee. My lord will
Lifetime trustee, maybe the lifetime trustee.
my lord would kindly
That
take.
does not mean that you are the managing trustee.
That is their plain case also, that I am the lifetime.
Suit has been filed alleging that you are defalcating
I'm
funds. It's a serious allegation.
But that, my
What
lord,
happens if the funds of the trust are siphoned off by you?
that's why, my lord, let there be auditors, my lord, and the auditors let them oversee everything, my lord.
Then there'll be friction at every stage. You won't let the auditors function.
But the audit, well, there are two
If you
audit.
want, very well. We can do this. We can permit you to carry on functioning, but every decision has to be passed to the auditors. Every decision. And if there's a serious dispute, the auditors will be at liberty to approach the court.
Well.
Auditors and any party.
Well.
Yes, Mr.
As
Comfort.
it fell from your lordship, Lord, it was only because this allegation of default.
No, if they function under the aegis of the auditors, they have to approve every decision through the auditors.
I do
Then
not have
there's
any
no-
problem, Lord. I only want a transparency to be maintained and court to be in session of the entire, Lord, custody of the whatever.
Mr. Ringsia will speak on your behalf whenever he wants to act against you.
অডিটরদের যদি অ্যাপ্রুভাল নিয়ে প্রত্যেকটা ডিসিশন নিতে হয় কোর্টের রিপোর্ট তো বলবে প্লাস অডিটরদের প্রত্যেকটা ডিউটি ফাংশন নিয়ে থাক let me
Lord,
carry out this.
why this problem came up, Lord, I had indicated, Lord, a supplementary affidavit I had filed. Lord, in the teeth of your lordship's order, Lord, he has, Lord, crowned himself to be the managing, Lord.
No, that will be curtailed now. If these auditors are consulted, their approval has to be taken.
He has declared himself to be president, and
Yes,
he's
so what? So
controlling
that's
everything.
sub judice in the suit.
That's
His declaration is immaterial.
That's exactly what is. That's why, Lord,
We are not, in any event, we won't be. The trial court also did not injunct him from giving out whatever.
Huh.
You feel you are the king of the world, you give out. Who prevents you? People will have the impression that you are a madman. What is the difficulty there? Let him give out whatever he wants.
Lord,
But that was not also the tenor of the order of the trial court. Trial court injuncted him from operating the funds.
by
or
way of
operating-
those two reads. By way of those two reads, Lord, the trial court
So
wanted.
that is a final relief. Let whatever affairs are there continue, but every decision will be subject to this.
Yes, my lord, because the day-to-day affairs of the
Lord,
trust, my lord, the auditors.
What will be your fun in running the trust if every decision has to be passed to the auditors?
In any event,
Why leave it to you at all?
Titikshan on though.
My lord,
Why
the
leave it to
auditors
you
are
at all?
there to, my lord, to see that there is no mismanagement, my lord. The auditors are being appointed to see that, oversee that there is no mismanagement at all.
No, Lord, I do not understand what is the problem if the auditors run the show.
No, they will be outsiders.
They are
Mr. Komkar.
absolutely
Difficulty is they are
outsiders, my lord.
absolute
That will be
blank
the
outsiders. They won't have any because this person has been in the trust. He's a life
But
trustee.
that's why joint auditors are there. So, Lord, it does not
No.
become an autocracy.
Otherwise, the function will in any event be paralyzed if the auditors are totally to run the
Lord,
trust.
may I only pray for one thing? If
Yes.
whatever is falling from your lordship, Lord, I do not stand in the way. Only one thing. Lord,
They'll give quarterly reports also.
Yes, very good. Lord, by virtue of this, Lord, litigation and whatever the orders have been passed, Lord, I have been completely ousted from, Lord, getting into
So
the
that
process.
you will get back when you.
That, Lord, if your lordship
That is
would
the
kindly
current position when
clarify.
the suit was filed, Mr. Korma. We cannot restore status quo ante in the garb of this.
If I can have some access to the
No,
past
we
only,
won't
Lord.
say anything to that effect.
Your auditors will be there.
Yes, the auditors will.
Wait.
That's what we said. Mr. Ringse will protect your.
Very good.
The parties, comma, as per previous direction, comma, suggest names of one auditor each. Full stop, next para. The matter arises out of an injunction order in respect of the functioning of a trust. Full stop. There are serious disputes between the parties. Full stop. Whereas there is plaintiff stroke respondent number 1 alleges that the said respondent has been ousted from the functioning of the trust, comma, serious allegations are also leveled against the appellant number 1, defendant stroke appellant number 1. For sub next para, learned counsel appearing for the appellants, comma, on the other hand, comma, submits that the appellant number 1 is a life trustee, even as per the life deeds of trust, and thus, comma, cannot be shunted from the functioning of the trust. Full stop, next para. Upon hearing learned counsel, this court is of the opinion that in the event joint auditors are appointed to oversee the functioning and financial activities of the trust, comma, any apprehension with regard to siphoning of the funds can be allayed. Full stop, next para. Accordingly, comma, in the light of the observations recorded in our order dated May 5, 2026 and July 27, 2026, comma, FMA 362 of 2026 is disposed of by modifying the impugned order bearing order number 10 dated January 29, 2026, passed by the learned district judge at Hooghly in OS 01 of 2025 to the effect that the joint auditors named by the parties, comma, namely Mr. Samir Sharma, within bracket ICAI membership number 061763 bracket closed. এখানে মোবাইল নাম্বারটা এটা দেখে করে দিও, এই ডিটেলসটা এখানে দিয়ে দিও, পুরো ডিটেলসটা দেবে, হ্যাঁ পুরো। অ্যান্ড মিস্টার সঞ্জয় কুমার রিংসিয়া, ওই ডিটেলসটা দিয়ে দেবে, are hereby appointed as joint auditors to oversee the functioning of the subject trust. Full stop, next para. The appellant number 1, comma, who is presently at the helm of affairs, comma, shall subject each and every decision, comma, including financial decisions of the trust to the scrutiny by the said joint auditors. First up, only subject to approval by both the said auditors shall any financial activity and other activity relating to the trust take effect. First up, next para, in the event there is any doubt or lack of consensus between the auditors and or any other issue regarding the functioning of the trust, comma, it will be open to the parties and stroke or the joint auditors, comma, together or separately, comma, to approach the trial court with an appropriate application in that regard, seeking appropriate orders. For sub next para, this arrangement shall continue till the disposal of the suit, but shall be subject to the final outcome of the appeal and stroke or any further order stroke arrangement, comma, if passed or made by the learned trial judge during the pendency of the suit due to subsequent developments. Full stop, next para, it is made clear that no special that the above order shall not create any special equity in favor of either of the parties, and the learned trial judge shall decide the suit independently in accordance with law on its own merits without being influenced unnecessarily by any of the observations made herein or in the impugned order. Full stop, the remuneration of the special officers, the joint auditors, shall be borne equally by the parties. Full stop, the remuneration for the equally by the parties, comma, the respective remunerations being borne by each of the parties in respect of the joint auditor nominated by them.
But only one thing, Lord, the injunction that your lordship imposed will continue, Lord, with respect to the transfer of the assets of the
Acha.
trust
Uh,
and appointment and removal of any.
The the parties are hereby further restrained from transferring and or alienating in favor of third parties the assets of the trust, as well as from appointing or removing any of the appointing new trustees and or removing any of the existing trustees, comma, also till the disposal of the suit. Pending application যেটা আছে দেখে নিও, can such and such is also disposed of accordingly, no address to cause. না আরেকটা লাইন অ্যাড হয়ে যাবে এর আগে, যেখানটা বললাম যে ওই till disposal of the suit, the joint auditors shall file quarterly reports with regard to the accounts of the trust before the trial court.
Great. And not only one thing, Lord, the joint auditors will also be, Lord, at liberty to approach the court in.
You have
case of
said
some-
that, you don't hear it.
I'm sorry.
Yes. Not only they can approach separately or jointly, whichever way.
My lord, item number 2, I am applying for the petitioner appellant. Last occasion, my lordship directed the.
What about the service?
Yes, my,
Nin,
to serve the copy.
can't hear you. Please use the microphone.
I am adding.
Use the microphone.
My lord, the lordship directed to serve the copy upon the erstwhile learned advocate. I have served the copy. Well, I have filed an evidence of service, my lord.
Yes, to dispose of the matter. What is the matter about?
Madam, my lord, 232 days delay, my lord.
Oh, that.
Well, My lord, on the time petitioner
This is a
Uh,
restoration application.
limitation application. I filed a limitation application and restoration.
No, restoration.
Restoration is good. Section 5 টা dispute default হয়েছিল। The section 5 is for the second appeal itself.
Itself.
You have served copies of both the applications.
Yes, my lord.
Why the restoration? Why was it
My
dismissed for
lord,
default?
232 days delayed, my lord. For my lord, I have filed a
32 days delay in filing the appeal or the restoration application?
restoration application.
In the condonation application, you have stated 232 days
My lord.
being ACT number such and such. What does this mean?
230 days delay. I have stated in paragraph 6, my lord. In detail. Paragraph 6. Condonation of delay.
Have to make at least a proper prayer in your application. You have to say that the delay is in filing the restoration application. ঠিক আছে? Operation Sindur side please. You are delayed due to Operation Sindur.
Operation Sindur, my lord.
What were
All
you
that
doing
time
there?
I was on duty as a soldier, my lord.
You were
At
in the
Kashmir.
front.
My lord,
You were in the front border.
border, my lord.
Where have you stated that?
My lord, paragraph 6, my lord. Paragraph 6, my lord.
Where were you posted? This is very vague. If you want to take advantage of Operation Sindur, you have to be very specific.
Yes, my lord.
The sentiment of the entire country is connected with that.
Yes.
So you have to be very specific where you are posted.
My lord, at
Just
Kashmir,
saying
my lord,
Operation Sindur won't do,
and
like
my lord,
COVID.
my lord, I was posted at Kashmir border.
You have not stated anywhere. Should have stated somewhere. Anyway. Affidavit of service filed to be kept on record. Full-stop. Despite service, none appears for the respondent at the time of call. Full-stop. Next para. The delay in as per the application for condonation of delay, comma the delay of about 232 days in preferring the restoration application was due to the appellant, comma, who is in the armed forces, comma, being posted in the front during Operation Sindur. Push up next para. We find from the averments, comma, which stand uncontroverted, comma, that a sufficient ground for the delay has been made out. Full stop. Accordingly, Can 2 of 2025 is allowed, thereby condoning the delay in preferring Can 1 of 2025. Full stop. Next para. From the restoration application, comma, we find sufficient reason, comma, pertaining to the mental state of the appellant at the relevant point of time for the appellant not being able to take appropriate information from his counsel during the relevant period. Full stop. Next para. Accordingly, Can 1 of 2025 is also allowed, comma, thereby recalling the order dated November 22, 2024 and restoring SAT 92 of 2024 to its original file and number. Full stop. This appeal was not admitted under Order 41 Rule 11.
No.
The appeal shall next be listed for hearing under Order 41 Rule 11 of the Code of Civil Procedure on August 24, 2026. Next Monday, it will appear under the heading Order 41 Rule 11 for admission hearing.
number 3.
Lordship, item number 3, I am for the state lordship along with Mr. Bhattacharya, senior standing counsel lordship. Lordship,
Yes.
I prefer not today lordship because due to his health lordship. Lordship, kindly fix it on Thursday lordship.
This is that matter where I had pointed out that this was an application for withdrawal of the money deposited by the state. I had brought it to your lordship's notice that reference arising out of the same acquisition proceedings stood concluded by a judgment of a court
Anyway,
of
since he's
division
asking
bench.
for time,
So
Mr.
I don't mind, my lord, whenever it's convenient.
Good.
Lordship, kindly fix it on Thursday.
Thursday.
Thursday lordship.
On the prayer of the learned counsel for the appellants,
Oh, in
the hearing of the matter stands adjourned to
20th, August 20.
August 20, 2026.
obliged.
Eighth lordship.
Item number 4.
My lord,
I prepare for the respondent wife.
What
my
is the
appeal,
defect?
my lord.
What is the defect?
Defect, my lord.
You don't know your own appeal's defect. You didn't find the time to check up the memo.
Sorry, extremely sorry, my lord. I did not notice, my lord.
This is against what? A divorce decree or what?
From decree, my lord.
Divorce decree passed or refused?
Passed, my lord.
So in a memorandum of appeal, you should write memorandum of appeal from original decree. You have written order. Leave is granted to the learned advocate and record for the appellant to rectify the caption of the memorandum of appeal during the course of the day. Instead of order, it will be decree. Please do that during the course of the day. Yes. What is the application?
My lord, the application is, my lord.
Stay.
My lord, yes, my lord. Application for
Yes,
stay,
you have
my lord.
remarried.
No, my lord, he has not come up against the decree for divorce. There are two parts.
My lord.
One is permanent alimony and other is divorce. He has come up solely against the grant of permanent alimony.
From, my lord, I have challenged the quantum of the, my lord, Alimony, my lord.
So divorce, you agree.
Divorce, my lord, I concede, my lord. Only my appeal is limited to the quantum of the, my lord. I earn a sum of rupees 3,000 per month, my lord. Permanent alimony has been given 20 lakhs. But there are certain, in terms of,
What have they disclosed in their opposition?
my lord, they have said, my lord.
Are you using any reply to this opposition?
Yes, my lord, I have already used, my lord. My lord, reply to
You
the.
can find on record any reply.
My lord, yes, my lord, reply, my lord, I am filing here and now.
I have to ask you every time.
একটা copy কেন? একটা copy কেন?
Since the appellant is not prepared with the affidavit in reply, comma, let the matter stand adjourned for the day. The affidavit in opposition filed today be kept on record. Come back tomorrow.
Black color, Ishan.
Item number 5.
And I am for the appellant.
Yes, Mr. Pal, what is the matter?
I am for the appellant. My learned friend's application is before your lordship. That is for maintenance. She has paid for 30,000.
There is a defect in the memo. Memorandum of appeal written from original order. It is from an order or decree.
Decree.
The leave is granted to the learned advocate and record for the appellant to rectify the caption of the memorandum of appeal during the course of the day. Original order is written, the decree. Yes, what is your application?
My lord, my application is my application for maintenance.
Maintenance.
My lord, I'm
This
filing the opposition, my lord. Opposition to their reply. I'm filing the reply to their opposition, my lord. They have filed a reply.
My opposition is here, man. I have to copy. Any.
So your affidavit of asset you have also annexed.
I have annexed the
Well, my affidavit of assets, I missed it because it was ready. The client could not come to affirm it.
How
This is
can
the
we-
thing.
statement.
No,
My statement, bank statements are all there. Only is the formal
I
application.
mean, there has to be a form of
Has to be,
affidavit of asset
has
now.
to
Without that, what was the last amount granted
be. 15,000.
Last amount granted was 15,000
in the trial court?
in the trial.
We are paying 15,000 up to November. Now my client, I've asked my client. He said, I am ready to pay 15,000 per month.
My lord, in the meanwhile, the main problem is the daughter. There's a daughter who is adult, who is 21-year-old. she was staying till 2023 with father. Now daughter after 2023 has come to stay with the mother. Now that there are expense, before that mother was not bearing the expenses of daily day-to-day food and lodging and clothing. Now day-to-day clothing, food, all is being borne by the mother.
What is the expenses for the daughter now, according to you?
According to me, another 15,000. The both can survive well with 35,000.
What does he do? What does he do?
He's a bank manager. He's a senior bank manager, and he's paying nothing since November 2025.
So that,
he is
that
paying
will direct him immediately.
He's paying
Mr.
7.
Pal, why don't you pay another 15,000? 21.
I am paying
old is a young lady.
15,000
For the no,
and 7,000 I am already paying regularly towards my daughter's expense. Regularly.
have you annexed that anyway? Must be
Yes,
there.
ma'am,
In
the
your,
bank
that
statement
from
is
that
there. Even my
7,000
daughter's bank statement is also annexed.
My lord, from that my humble
And they have
submission-
admitted that.
my lord, my humble submission is that in today's present time, inflated world, he is
you want
paying,
8,000 more then?
yes, my lord, no, he is paying 7,000. 7,000 is pocket money to the daughter. Daughter is spending the entire amount. She is gives me 2,000 rupees
Education
to the
expense?
mother. Let me submit, sir. She is giving 2,000 rupees to me in the month. And then she's sending the bank statement to the father that on account of food, I'm sending 2,000 to mother. In today's world, 2,000 rupees, is it enough to even have a boiled rice?
So you will have that 15,000 which you are getting in the trial.
Yes, but at
That
that time
you
I
have.
was at that time I was staying
That
alone.
will direct, definitely. That is agreeable also virtually.
At that time I was staying alone. Now change of circumstances happened.
See,
Daughter is staying
You
with
get
me.
your 15,000, daughter is having 7,000 from them already. You don't take another 2,000 from the daughter. So we can direct them to pay 8,000 more to the daughter. You were saying you are asking for the daughter, more for the daughter.
If that can be done, that is fine.
So 8,000 for
8,000 further, 10,000 further. She's a young girl. She's having from morning to night. She's having various food necessities.
plus 7,000.
Plus 7,000 is a pocket money, my lord.
What's the difference between pocket money and
Pocket money she's
maintenance?
spending to go to colleges.
Whether she
and
keeps it in her pocket or spends it, it's on her.
spends on her. I'm asking for fooding. I'm only asking for fooding. If 15,000 is high,
Because you have to bear that.
I have to bear that. From morning till night, I have to bear that.
Mr. Pal, don't give it directly
And,
to the
and
daughter.
also medical expenses.
If you directly give to her pocket money 7,000, you are welcome to do that. But then mother also has to take care of her
But
shelter,
I am
food,
paying,
everything.
Lordship. She should have disclosed it. Her education expense. I have disclosed it. And per year, I am paying about 24,904 towards his
Education
insurance.
expenses, entire education expenses. You are
Intelligence, I have paid all 1 lakh rupees.
No, this cannot be piecemeal argument. You have not said you had your turn. Sorry, you have suppressed this.
No, my lord,
No, you have suppressed this. Sorry, ma'am.
my lord, my humble submission. I have
No, your humble submission has to end somewhere. Please.
only
No,
voting, my
they are arguing. Why are you disturbing? Please take your seat.
deeply.
You have got your chance twice. You
I
did not
apologize.
disclose this.
I
Take your
apologize.
seat. Take your seat. You cannot have a chance every time Mrs. Pal speaks.
My lord,
We gave you 2 chances. You did not disclose that he's paying for the education.
my prayer is only for fooding.
Please take your seat. Yes, Mr. Pal. What else are you once and for all? You argue, complete your arguments. We'll hear her
My
pass
lord,
our order.
For
You are paying the entire education expenses.
entire
Where do you
education
find that?
expense.
Show us.
plus 7,000.
Show us where we get that.
This other education expense. এটা ওদের আমাদের
The position show us where you're paying her education.
Page 114.
114 is the
It starts from
প্রত্যেকবার একবার
112.
করে
starts from 112, whereas the receipt is there, my lord. 111, 112. These are the
Education
receipt,
expenses.
education expense towards college fees.
This is what is she studying there, Mr.
Law, LLB.
What school of law?
Law school.
What is this ASIC?
These are the, my lord, money receipt.
114, page 114. What is this?
114.
Entrance exam and all these things.
Yes. Enter that.
3,000.
Now, my lord, for a admission to the law college, I have to pay 1 lakh rupees.
Whatever you have to pay, you have
I have to pay. I have paid it.
You are paying the entire educational expense.
Education regularly, apart from 7,000.
So pocket money 7,000 you will bear. You are agreeable to bear. 15,000 for her, 7,000 pocket money for the daughter and her entire education.
I am already bearing.
But
What more she wants? She wants 30,000 in her account.
Only one thing. There are some expense for the food of the daughter, other tidbits also. 7,000 does not cover her fooding. At least add something more. throughout the month, the daughter needs something to eat also.
Now, 498A,
Whatever, whatever.
that was dismissed. She could not prove it, could disbelieve the.
498 has
No, nothing,
no
has no
connection
bearing
whatsoever
apart from the
with
merit.
section 24.
Apart from the merit, there is no bearing. But I am saying the conduct, my lord, this is how.
Bad. Maybe you say from your perspective it is bad, from her perspective it is good. So, but we cannot decide by that what
That's
expenses
true.
are
When I
equal
go to, that's that is good.
daughter, Mr. Pal, definitely pocket money you are bearing, we can understand.
22 years.
A young lady needs her pocket money, definitely. 7,000, fine. Educational expenses you are bearing, fair enough. We agree with that. That is very fair. But the mother is having to bear. She's staying there, having her other expenses, clothing, food. These are there. So we will add something more. Let it be 15,000 for the daughter also, including that 7,000.
30,000 is difficult, my lord. 30,000 plus
You are
7,000.
bank manager.
30,000 plus 7,000. Then education.
No, no, no. 7,000 included. Total 30,000.
8,000 additional.
We are not complicating it. Total 30,000 for daughter and her, and education expenses.
Then my lord, 15,000 to be paid separately to the daughter.
No. Then the daughter has to take care of her own shelter, and then we are sending back the daughter to you.
I am ready.
Daughter herself gone. She's 21 years.
She
Can we do
went to her
that?
mother. She was staying with me for 29.
You are paying pocket money, that's fine. But pocket money, the mother has to pay for her food and shelter.
Rightly, my lord. The pocket money does not include fooding. That I am agreeable.
So very well, you pay 7,000 to the daughter, education expenses direct, and plus 8,000 to the mother for the daughter, for other expenses of the daughter.
Can you make it 25? I am not bargaining.
No, 30,000 is fine. What is your income per month?
1 lakh 24,000.
1 lakh 25. So 30,000. So let us make it then more. 1/3. No, not 1/3. A bit more. Including the daughter, 1/3 for the wife. And so you enjoy 1/3 of your income, and we are making it 2/3 for the half, 1/3 for wife and 1/3 for the daughter.
I have to leave the house.
You leave your house. You live in the bank.
Let them later come to my house. I am not objecting.
No, these are obsolete submissions, Mr. Pal. We didn't expect this from you.
No, no, this is only.
Obsolete archaic submissions.
this
Let her
is
come
only-
back to our high.
Oh, this is only the
If you
two.
behave well with her, she'll definitely come
No,
back to
this
you.
is only my lord. Loud thinking, nothing more.
No. We will make it 8,000. So 7,000 you pay directly to the daughter per month. Education expenses you pay direct. 8,000 to the mother for the daughter, plus her 15,000. We'll make this. Let us hear her on this. We have not yet heard her. We'll made her sit down. Now
That
she has a
15,
say.
that 15 includes 7,000. Then it
Yes,
is
sir.
37,000.
15 who is
No, no, no.
saying?
Yes, sir.
15,000. No. 15,000 for the mother.
Mother is
Separate.
okay. Mother is I am not on
We are
that.
saying, we are again repeating. Mr. Pal, please just pay some attention. 15,000 for the mother exclusively. 7,000 direct to the daughter for her pocket money. 8,000 to the mother for daughter.
Okay.
And education direct. Yes.
I'm agreeable to
Thank
this.
you. Heard learned counsel for the parties, full stop.
These
The
are
affidavit in
the-
opposition and reply filed today be kept on record. So the next para, it is an admitted position that during pendency of the suit in the trial court, the appellant husband had all along been paying rupees 15,000 per month to the respondent wife as alimony pendentility, which amount has been paid up to the month of November 2025. Full stop. Next para, learned counsel appearing for the respondent stroke petitioner submits that although the appellant is paying pocket money directly to the daughter, the daughter is using it for her own expenses without and paying and handing over a paltry amount of rupees 2,000 per month to the daughter to the respondent mother out of the same. Full stop. It is argued that the same is not sufficient to bear the monthly expenses of the daughter, who is a young lady of about 21 years. Full stop. Next para, that apart, learned counsel submits that the amount of rupees 15,000 which was being paid to the wife during the trial should at least be paid to the respondent exclusively, particularly keeping in view the rising costs of things and prices. Full stop. Next para, learned counsel for the appellant husband submits that the appellant husband has been bearing the education expenses of the daughter by making payments directly, comma, which is also borne out by the annexures to the affidavit in opposition of the respondent. Full stop. That apart, comma, an amount of rupees 7,000 is being paid by the appellant husband directly to the daughter as her pocket money. Full stop. Next para, thus, comma, learned counsel submits that the respondent, that the daughter of the parties expenses is being sufficiently met by the appellant. For the next para, upon hearing learned counsel, comma, we find that in modern times, comma, an amount of rupees 15,000 per month as maintenance for the respondent wife would suffice, comma, particularly keeping in view the monthly income of the husband, which is about rupees 1,25,000.
1,24,000.
24,000. For sub next para, that apart, comma, since the appellant is already bearing the education expenses of the daughter directly, as well as paying an amount of rupees 7,000 as her pocket money directly to the daughter, comma, a further sum of rupees 8,000, comma, payable to the respondent wife for the other expenses of the daughter, comma, including food, shelter, clothing, etc., would suffice for the present. Full stop. Next para. Thus, comma, litigation cost have you paid any?
Litigation, my lord,
Paid
litigation
for,
cost.
what is the litigation cost you have paid?
Litigation cost I have paid, my lord.
Yes, he has asked for 40,000.
40,000 is reasonable nowadays, High Court. This is reasonable.
My lord, I am leaving it to your lordship. It will be too much for us.
40,000 too much. Nowadays, the litigation will continue for some time also.
My lordship, can you dispose of it next week?
Oh, so easy.
It will not continue.
So fantastic. We are machines.
No, my lord, not machine. It will not
Accordingly, we dispose of Can 2 of 2026 by directing the appellant husband to pay a monthly amount of rupees 15,000 for the exclusive expenses of the respondent wife, comma, along with an amount of rupees 8,000 per month also to the respondent wife for meeting the expenses of the daughter of the parties, the unmarried daughter of the parties. Thus, comma, the appellant shall pay a monthly amount of rupees 15,000 plus 8,000 equal to rupees 23,000 directly to the respondent, comma, full stop. Over and above the same, comma, the appellant shall go on paying rupees 7,000 each month directly to the daughter of the parties as the latter apostrophes pocket money, as well as meet all educational expenses of the daughter, comma, as and when the same arises, comma, also directly. For sub next para, the above payments in respect of the wife and the daughter, comma, apart from the educational expenses, comma, shall be paid by the 7th day of each current month, comma, the first of those arising, the first of which shall be payable for the month of September 2026, comma, to be paid by September 7, 2026, comma, to the respondent at her bank account. Did you pay previously at the bank account directly?
Directly.
To which it was being paid during the trial. For sub next para, over and above the current amount of alimony as directed above, comma, all arrears of alimony, comma, calculated at the rate of rupees 23,000 per month from December 2025 till August 2026 shall be paid by 3 equal monthly installments by the appellant to the respondent, comma, the first of which shall be paid by August 31, 2026 and thereafter by the end of each succeeding month. For sub next para, the appellant shall also pay litigation costs of rupees 40,000 to the respondent wife for the present within September 30, 2026. Full stop, no others to cost.
Well,
Paper books have been, directions have been given.
Paper books have been
Trial
done.
court records have come and
Paper books have been done.
only one thing, my lord, to make it clear is that 7,000 which I'm paying to my daughter, that is current. So there is no area towards.
No, no, only this we have stated. Only 23,000 we have specified. 23,000 areas regarding 23,000.
23,000.
Yes,
Yes.
we have specified in our. That's right.
Grateful, my lord, deeply.
I'm grateful to you. So Lordship, kindly make it matter to be appeared in the list as a hearing at any day. After some time, my lord.
It may become more costly for your client then. Permanent alimony will be more costly. Yes. Let it continue as it is for the time.
Grateful, my lord, deeply obliged.
Thank you, sir.
Right, my lord.
Call করুন।
As for your lordship, last direction.
Last direction, but you have this resolution today. Rain is falling outside and we are not having matters. Fine. Fine with us, no difficulty. None appears for the respondent. Full stop.
So this is my physical service of notice upon the learned advocate for the
What service?
service. Physically I have served.
Physical, actually. We thought
Sir.
digital. The receipt of service filed to be kept on record. Full
Along
stop.
with the order.
Despite service, none appears for the respondent, although the appellants are represented through counsel. Full stop. Next para, let the matter stand adjourned for the day.
Item number 7.
Yes.
The respondent, my lord, my lord, that 2G matter, my lord, had heard in details, my lord. The depositions were placed on the last occasion.
Outside, 3G is falling outside. The none appears for the appellant, although the respondent is represented through counsel. Let the matter stand adjourned for the day. It was to be heard, actually. The appeal was to be heard.
My lord has already heard the appeal, my lord.
Yes. Let them have the advantage of the rain for a day. Yes.
My lord, I am for the appeal and petition.
For the respondent.
There are two applications,
And
my lord.
in this matter,
One for injunction and another for, my lord, maintenance. My
Your
lord,
lordship,
both,
What was deposited out of time, something?
my lord, so far as the 2 days delay was, my lord, in
In depositing what?
depositing matter special messenger cost for bringing the record
your
from the
lordship,
lower court.
You
My
have
lord,
filed your vocalat number till now.
no, already filed in this matter, advocate Jui Dotto Chakraborty is for.
Yes, there's a defect. The office report says no vocalat number has been filed by you are Mr. Bidhan Modak.
Yes, lordship.
So Datta Chakraborty and Bidhan Modak appeared before the bench on the last occasion. There is no vocalat number filed by you. When did you file your vocalat?
Already filed.
Give a copy of that. We'll keep it on record. Do you have an extra copy of that? Do you have the entry number? Filing number?
Not filing date, lordship.
No number is given there. Your clerk
No,
should know
lordship.
the number.
Only just lordship photocopy I have.
Very well. We'll do this. We'll direct the office to give another report on this. You satisfy the office. You ask your clerk to go to the office and with a copy of this and give them the number. And regarding this application, what do you have to say?
Your lordship, in this matter, advocate Jui Dotto Chakraborty is
That
for
you have said. So
kindly not to the lordship.
you are there, Mr. Modak. You
No,
oppose the matter.
Yes, lordship, but today
Maintenance matter it cannot be kept on hold for long. No.
kindly for a 1-day accommodation, lordship.
You have filed your affidavits, Mr. Mitra. Alimony application is there.
alimony application is
You are
there.
challenging a divorce degree. Or
Challenging a divorce degree.
so, is there any subsisting injunction at present? Have you granted injunction?
No. The injunction applications we have made also, my lord. That is can 3.
No. Acha, condonation was allowed only on the last.
Condonation was allowed. Thereafter, my lord, we filed 2 applications. Can 2 is for maintenance.
And can
Can
3
3 is for injunction.
Can 2, you also have to file your affidavit of assets now, Mr. Mitra, as per the Rajneesh versus Neha format.
Yeah.
So you file it, will give you 1 week's time. Injunction you are granting for the time being, but you file your affidavit of assets also you have to file. Both parties have
I
to.
have giving details.
No, that will not, that there's a format of Rajnish Neha. You have to comply with that. How soon can you do that? You have the facts.
My lord, facts, I will have to, my lord, then
So take-
10 days minimum.
10 days, why minimum? We'll give you 2 weeks.
2 weeks.
Your alimony application. Anyway, an adjournment is sought on behalf of the respondent. First of next para, in view of there being urgency in the injunction application, comma, we find that a sufficient case for ad interim injunction has been made out, comma, in view of the appeal arising out of a divorce decree obtained by the respondent husband, and in the event no injunction is granted, comma, the appeal may be rendered infructuous. Full stop. Accordingly, the respondent is restrained by an order of injunction from contracting any remarriage during pendency of Can 3 of 2026. Full stop. Next para. The appellant stroke petitioner shall file affidavit of assets in connection with Can 2 of 2026 within a fortnight from date and serve a copy thereof in advance to the learned advocate for the respondent. Which of next para, composite affidavit in opposition to the alimony application and the wife's affidavit of assets shall be filed by the respondent husband, comma, along with his own affidavit of asset, comma, within a fortnight thereafter. Full stop. Composite reply thereto shall be filed by the appellant wife within a further week. Full stop. Next para. The matter shall next be listed for hearing in the monthly list of October 2026. Full stop. Next para. In the meantime, comma, since it is submitted by learned counsel appearing for the respondent that the respondent has filed his vakalatnama, comma, the office shall furnish a revised report before the returnable date in that regard. Full stop. The learned advocate for the respondent is requested to contact the office and furnish the particulars of the vakalatnama filed by the respondent to that end.
And my lord, so far as the delay in depositing
the delay in depositing the special messenger cost is condoned, and the said costs are hereby accepted as valid, which of the office shall act upon it. Tell your client not to remarry in the meantime, and you contact the office. You ask your clerk to contact the office with the vakalatnama.
Item number 9 to 16.
My appeal, my lord, number 9. My lord,
I'm appealing to the respondent
my
number
lord,
2.
the short point, my lord.
Respondent 1 has been served.
Services.
They are looking at each other, so you have to say, and you are looking at both of them
At the same time.
at the same time, simultaneously,
হয়েছে কি হয়নি?
with a peripheral vision, which is very strong.
No, it is not with us. This affidavit of service, I'm
No, that needs not be. What is now appearing before us?
yes, can appropriate order, my lord, the court never passes any inappropriate order. Now, my lord,
Then why did you file an application for appropriate order?
appropriate order, my lord, this is my lord, here the short point, my lord, that has fallen for consideration, my lord. First of all, that the Shali and Danga, my lord, this was requisition under 1948 Act.
Shali and
Danga, the land, agricultural land, my lord. Now, my lord,
it's agricultural land.
my lord, what happened? My lord, 81, my lord, the possession was taken. 83, the date of notification. 2000, the LA collector passed the award.
Acquisition under which act, Mr.
48 Act. My lord.
48 Act.
48
State Act.
Yes, State Act. Now, my lord, possession was taken 81, notification 83, and my lord, award passed 2000. Now, my lord, ultimately, this was, my lord, culminated into Section 18, 2nd February 2026. The court, my lord, under reference court, my lord, had passed the award in my favor, or holding inter alia, my lord, that I am entitled to get compensation, enhanced compensation, and the interest that was accrued thereupon, that is on the enhanced rate, not from the date of taking possession. Section 34 says, subject to correction, my lord, that two conditions of the that section, that money has to be deposited within 1 year from the date of possession, subject to correction, and second, my lord, that
the section 34 paragraph 10, my lord, that it says, my lord, when the amount of such compensation is not paid or deposited or before taking possession of the land, the collector shall pay the amount awarded with interest thereupon at the rate of 9% per annum from the time so taking possession until it shall have been so paid or deposited, provided that
48 Act, Acquisition Act, West Bengal Jila Act. Landlords এগুলো ছিল। ওহো, you're for the state, Mr.
No, I am for the respondent number 2. Here, my lord, we have not made the party in the original proceeding, but in the appeal, we have made the added without any applications.
No service of
No addition of what the application was.
48 Act, 1948 Act, Stated Act.
We are the transmission company limited.
No, if you have not got copy, you should have said that at the outside, then he could have served it.
No, application for addition of
Ah,
party, because
48
original
Act.
suit, original reference.
Now you have already been added here.
In the appeal, they have added
You are not a party.
Initially,
in
the
the-
activated.
original
The reference code.
application.
Milord, section 34, Milord, I am referring section 34 of the Act, of the 1894 Act.
Let us wait for another copy of it.
1894 Act.
1894 Act. Initially, the acquisition was made under 48 Act, Act 2. That is why, Milord, the possession was taken before notification, 81. Now, Milord, 83, the award was passed, 81 date of possession, and then 2000,
ওই
আপনি
বইটা
1894 এর আন্ডারে, ওই তো ওটা আছে।
এই বইটাও দিন। ওনাকেও দুটো দিন।
ও, আপনি কি বলছেন, আপনি কপি পাননি?
Original suite ছিল, পাঠিয়েছিলাম না। রেফারেন্স অরিজিনাল রেফারেন্স
আমাকে পার্টি করেছিল
WBACTCL।
হ্যাঁ
WBACTCL।
WBACTCA
হ্যাঁ, এখানে পার্টি করেছেন WBACTCL।
দাঁড়ান, কি বলছে, কপিটা দেওয়া হয়নি বলছে।
Which was the requiring body?
Well, requiring body was, Milord, the
Initially WBACD was.
ACB.
Subsequently, that transmission was handed over to WBACTCL. In the reference case in 2023, they have added WBACDCL, Distribution Company Limited. Therefore, they have not served any copy upon transmission company.
What happened? They were not expunged from that proceeding. DCL did not say that they are not the requiring
They
body.
have not, my lord, they appeared, but what they have stated in
They lost the case for you. They lost the case for you
yes,
on your behalf.
and the state has not. Further thing, my lord, one reference was also went to the Supreme Court, and Supreme Court made a guideline.
Anyway, now you are a party. Let us see what they have to say.
আপনি কপিটা পেয়েছেন তো অ্যাপ্লিকেশনে?
এই application copy page.
সেটাই তো।
Original
Papers are not with you. If they prepare paper books, then everything will be given to you.
Now, Milord, section 34 of the 1894 Act, Milord, the reference has been drawn because for the paragraph I have said that payment of interest when the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at rate of 9% per annum from the time so taking possession until it shall have been so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation or
This
a
has
part.
not been awarded to you.
No, the LA collector, Milord, did not award any interest,
Reference code?
Milord. Reference code award interest, Milord. Suppose, Milord, the total valuation as is determined by the LA collector was 8 rupees. He said no, it should be 12 rupees. But he has, Milord, calculated interest to be accrued thereupon only the rest amount, that is 4 difference money, not from the, Milord, total amount. If your lordship pays 32, Milord, if your lordships kindly take pain, Milord, to go through the language, Milord, the compensation assessed, may I read for me?
Please see the section once again, just.
I'm sorry. আমি 1 আর 4 দুটোই বড়।
নোটিফিকেশন তো এটা পয়সা দিতে হবে।
Part was deposited, part was paid previously before the enhancement?
No,
Because proviso says that if
Yes.
such compensation or any part thereof is not paid,
yes.
then 15% on that
Yes.
not unpaid part.
Yes, I have two components subject to correction. The
Yes.
first one is that within 1 year from the date of possession, you deposit the amount, not to me, but before the LA collector.
That was done.
No, that is my instruction
That
is
is
not.
actual or not?
Yes, and when the award was made by the LA collector in 2000, he did not add any interest at the award part is nil. This point was not taken into an account in this judgment.
Page 32. We'll see.
Page 32, kindly sees how the 1 and 4, got it. 1 the compensation assessed at rupees at the rate of such and such 16,041 only per katha, that is rupees 9,70,481 per acre, thousands for 181 only per acre for Shali class of land and Danga and Pukur per class of the acquired land of the referring claimants comes to rupees 21,000 such and such per katha, that is 12,93,074, 12,93,700 only per acre in the respect of Mauja. Why I am taking my lord's kind attention to this clause? Because, my lord, in view of the Supreme Court judgment, my lord, there, if it is 50 meters away from the national highway, 500 meter away from, my lord, this difference, my lord, should be obliterated. That means, my lord, the price that has been determined as against, my lord, Shali and Danga, that should be the same. Such differences, my lord, cannot be made, my lord, in view of, that is my humble understanding. And paragraph 4, Roman 4, interest 9% annum on the entire amount of compensation, land value plus silicium additional compensation for the period of 1 year from the date of notification, and thereafter 15% annum till the paymentless amount already paid. Decree be prepared.
What about the state, Mr. Basu? Today the state is not appearing. State has to answer. What is this? Application is for what?
There is an application for the enhancement of the amount of this minute and the appropriate order minute.
That can only be passed when the appeal is allowed.
Yes, appeal is allowed. And I have also added certain documents. Documents mean the Supreme Court's last order that was not at page number 33, and also
that is a certified. I mean,
Yes,
you can
yes.
rely on that judgment.
Yes. I
That
don't
is
know
not a
why
new
it was.
Only another point, my lord.
So the paperbook directions have already been given.
No, first time.
So we can dispose of this application, or we can direct this to appear along with the appeal and pass those directions, paperbook and all.
Yes.
Yes.
In the 2018, my lord, we have, my lord, district magistrate had requisition for 4,59,82,000. We have already deposited. Previously, we have deposited, my lord, as per their.
Sir, I think we'll do this. We'll direct you to file
State
it.
is the necessary
We'll
party, my lord. Otherwise,
State has to come. We'll direct both you and the state to file opposition to this.
yes,
In the oppositions, you disclose all the dates of payment so that we can have a calculation ultimately.
yes.
And if you can give your calculations.
And on the basis of the judgment of the Supreme Court, the DM has asked this amount. Therefore, my lord,
We'll
we
decide
have
the
to-
appeal. We cannot decide these at this stage. None appears for the state at the time of call. Full stop. You are not filing any affidavit of service. You have to file
But
that.
affidavit of service is not with him. He said this.
Another point, my lord. When we are the
We'll hear all points, Mr. Rai. We are not deciding
No.
anything now.
well, initially we are, my lord, not the reference case. We have not made the party. Therefore, as in the appeal, without any addition of application of
Whether it can be implemented.
yes,
You keep that question open.
yes.
যেটা পর্যন্ত বললাম তারপর however no affidavit of service filed today, no affidavit service is filed today, full stop. Accordingly, the appellant is directed to serve a fresh notice on the state which is not being represented today, full stop. Next para, although the respondent number 2 WBSET T for transmission PCL is represented through counsel today, Common Learned Counsel submits that the WBSETCL was not a party before the reference court and has been implemented in the appeal without any formal application for leave or addition of party. Full stop. It is contended that such mode of addition of party is not sanctioned by law. Full stop. We keep the question of validity of the addition of WPSCTCL in the manner as done, open for being argued at the final hearing of the appeal, full stop. In the meantime, comma, the respondents shall file their affidavits in opposition to the connected applications within 3 weeks from date, full stop. Reply, if any, shall be filed within a fortnight thereafter. Full stop. Next para, the applications shall be listed along with the appeals. Full stop. The appellant shall prepare the requisite number of informal paperworks without comparing with the records within how much time?
Within 4 weeks.
Within 6 weeks from
6
date,
weeks.
full stop. Next para. The trial court records shall be brought by special messenger at the cost of the appellants to be deposited within a fortnight from date. Full stop. Liberty to the in view of the appearance of the respondent number 2 through counsel, comma, service of notice of the appeal on the respondent is dispensed with. The due requisites for service of notice on the state respondent shall be put in within a fortnight from date. The liberty of the parties to mention the appeal for inclusion in the list along with the connected applications as and when the appeals are ready for hearing. You have put that, you have tucked that friendship band inside your coat. Is it still there or?
Still there.
Still there.
Please don't.
Why have you tucked
Don't
it
add
inside?
anything.
Why have you tucked it inside? It's
No.
occasionally you can see it there.
It's visible.
Visible now. এই নামগুলো একটু
Item number 17.
Friendship is still alive. Created by the band.
Lord, item number 17, Mr. Supratik Shamal is appearing on behalf of the appellant. My lord, he went before, he is on his legs before that apex court, my lord, honorable apex court. I'm praying only for 2 days.
Before apex court is not a good
I'm
ground. We are
putting
not
the-
daunted enough.
For the
We are not intimidated by that. You start the matter.
My lord, I'm
He may
praying
be in his legs before the apex court. You are before the Nadir court. You please argue. Start arguments. Yes.
I'm
Apex court, appearance before apex court. If you had not said that, we might have considered granting adjournment.
my lord, I'm praying
If you
for,
say that, no, definitely we'll take up the appeal. Please move the matter. Yes, what is the matter about? Yes.
my lord, this appeal is, my lord, arising out of a suit for partition, my lord. My lord, to lordship may kindly come at
For partition, you have challenged the final decree or
No,
what?
my lord, I'm challenging the order passed under order 939 rule 1 and 2, my temporary injunction. What has happened before, my lord? Without considering my
The appeal has been admitted, must be.
my lord, by an order dated, my lord, 7th of July, my lord, this appeal has been admitted by this honorable.
Appeal along with the application we said.
My lord.
You are ready with the appeal also?
My lord, I am ready.
Very good, very good. Yes, what is the, let us see the order.
Yes, page 172 for the stay application.
What is your ground of challenge?
My lord, the ground of challenge, if your lordship may kindly see the earlier order, my lord, passed by this honorable court, my lord. My lord,
Not to change the nature and character only.
Yes,
But if you change the nature and character, what will remain in the suit?
No, that is not there, my lord.
What net is
Without
there?
there is another partition suit is pending, my lord. My lord,
Maybe.
without considering that thing, my lord. My lord,
That was considered, how it would make a difference? A partition suit is pending. You change the nature and character.
no, I'm not changing the nature and
That is the
character, my lord.
injunction granted.
My
We are
lord,
maintaining that.
the suit plot belongs to the state authority, my lord. My lord,
That
kindly,
question will be decided in the appeal, in the suit.
my lord, kindly see, my lord, page number 163. An FTA has been made, my lord.
That will be decided. That requires evidence to be adduced. At this stage, we cannot hold conclusively that the property belongs to the state. If it belongs to the state, their suit goes, both of your rights will go. But even if you say that the property belongs to the state, still you don't have a right to dispose of the property.
Only
Do you have a right to dispose of the property if the state is the owner? So we are accepting your stand. Even then, you don't have a right to. Injunction was passed rightly.
We are the, my lord, pro forma defendant in the suit. My lord, the
Injunction was passed against you also.
my lord.
State is the owner, you admit that.
Yes.
So how can you dispose of property, change nature, character?
No.
You cannot touch the property.
We are a club,
You are
my
protecting
lord.
the state actually.
We are a club, my lord. We are holding, my lord, Durga Puja in this.
Don't hold Durga Puja. Hold it
Sir.
in your personal premises.
No, my lord.
You must have a president, secretary. They have their houses. hold it in your own backyard. Why use a public property belonging to the state for this? Have you taken permission from the state?
Yes, 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 yes.
You have taken
Yes.
permission from the state also.
I have annexed the
Subject to
document.
that, you can always
No,
construct.
unless,
That does not change the nature and character. Character may be changed after Durga Puja, but nature
for a
is not
temporary,
changed.
for a temporary, my lord.
The character of the
For-
of
for a
the
temporary-
persons who are performing the puja may change. The character of the property should not be changed.
My lord, that is not the thing, my lord.
No, no, it cannot
My lord,
change the
my
nature
lord,
character.
my lord,
Where is
my
the
lord,
permission?
Why are you doing my lord, my lord, my lord, my lord?
Permission, my lord.
You are getting panicky.
Yes, my
Why?
lord, I'm praying for only.
Give us one reason why you should permit you to change the nature character and you get an order. One reason. You
Well-
say it belongs to the state. That entitles you to change the nature
At
character.
page 113, my lord, the permission has been granted on earlier occasion. my lord.
That permission only grants you the liberty to perform a Durga Puja there. And that is also subject to the outcome of the suit. We don't know whether the state is at all the owner of this.
They have made the state as a party to the proceeding also.
But that will be decided in the partition
My
suit.
lord, unless, my lord, this order, my lord, stays, my lord.
Change of nature character
No, I'm not changing the
cannot
nature.
permit you.
I'm not changing the
That
nature
is the
character.
injunction granted.
No,
If you
no.
don't change, then don't change.
In a permanent manner, I'm not changing nature and character, my lord. I am only for, my lord.
No,
I'm only
no,
concerned
no
with my.
nature character change. Sorry. Yes, we'll hear you when you come back. We'll come back and we'll hear you then. Yes, what do you say?
My lord, three cardinal principle of the my lord oral certainty rule 1 and 2, my lord, guided by the my lord principle, my lord, the lower court,
Can't understand. Yes, use the microphone.
my lord, only my lord, indication, my lord, two thing, my lord, the
Yes.
page 164, my lord, kindly similar the order proceeding in a read code, my lord, dated my lord 26th September 2025.
Yes.
My lord, kindly see, my lord, my lord, paragraph number 4. The fact of non-issuance of permission shall be communicated by the SDO to the officer in charge, Bhagwanpur PS. My lord, it was held, my lord, 26th September 2025. My lord, very next date, but till such date, my lord, there was no permission, my lord. And my lord, next page, my lord.
Oh, state took the stand that no permission was given.
Yes. But my lord, subsequently on 27th, very next date, permission was given by the SDO and BDO and puja was held. And my lord, subsequently, my lord, this injunction order was granted by the court below. And my lord, before that, my lord, here suppressed all these things, my lord. Before that, they moved an application to exclude from the my lord area of the party respondent. My lord, order 1 rule 10. Kindly see the order. In the same,
To exclude whom?
my lord, he makes a prayer, club makes a prayer.
Exclude whom?
Exclude the my lord, the club from the area of the respondents or defendants in the proceeding. My lord, that order was my lord, rejected. That application was rejected. Their suppression was there here.
What was their premise for making that application? What was the stand?
Plot of lands purchased by myself, my lord. And
what was their stand in that application?
Their stand was that they are the club. They are not have any right, but they are in a long time period. They are ensuing the puja time to time. This is the only stand.
No, is there order 1 rule 10 with you?
Yes.
Shows that. State is also a party in the suit.
Yes, my lord. In the present case, my lord,
why have you implicated the state in a partition suit?
My lord, they alleging that in a SPIO they made an application for RTI. What is the nature and character of the property or the whether any proceeding is pending or not? The LA collector issued that there was no such record available to the state, so that we cannot disclose anything. This is the stand of the state.
In a partition suit, why do you don't normally implicate the state? Why did you implicate the state? You
No,
are the
this is
plaintiff.
the cause that there was the RTI application by the club and reply was there.
So their RTI application, why do you implicate unless you admit the state to be a co-owner?
No, can you see the order of the my lord, the order 1 rule 10.
In the appeal, state is not a party.
No,
No, in the appeal, my lord,
I made the only the
division
plaintiff
number
the
1
party.
and 2 is not the
You
party.
cannot do it. You have the appeal is not maintainable.
Yes, my lord.
They have to be made at least pro forma defendant. Pro forma respondent, sorry.
No, this is the my lord order.
Kindly,
It's bad for defect of party.
That was not even challenged with the court of law.
kindly leave my lord to implicate them as the party, my lord.
Where is the plaint?
My lord,
Where is the plaint?
plaint is my lord at page 134, my lord. This is their, my lord, amendment petition, my lord.
You have admitted in your order 1 rule 10 that you don't have any share in the property.
No, my lord, we always admitted that I don't have
Then
any
you
share.
don't have a right to make any change the nature and character of the property in any event. You admit you have no right title interest
My
in
lord.
the property. Then how can you change the nature character?
No, my lord, since long, my lord, kindly appreciate that fact, my lord. Since long we are holding that holding a Durga Puja.
Durga Puja is an occasional thing. Sorry, that's not a continuing person.
With a my lord, with the knowledge that that is
There is no vested right to make a Durga Puja.
That is the my lord.
Where are all the parties?
And my lord,
The correct array of parties in the plaint. Page 134.
None of them have been implicated.
Where are they gone?
Partition suit, all the parties are necessary parties.
My lord, kindly grant me liberty, my lord, to make an application, my lord.
Are you enjoying an interim order?
No.
You keep this with you. Did you direct it to file opposition to the?
my lord, that will be my lord
First time.
only for my lord.
Will not
This
do. You have to
purpose.
file a formal
There is
application.
no such appeal in the eye of law, my lord. There is such other defective also, my lord.
What other defect?
This is my lord the parties to the suit is not in the party.
Yes.
Before your lordship, my lord.
What else?
And other is this, my lord, the order, my lord, the temporary injunction against, my lord, defendant number 1 and 2, that was also suppressed in the proceeding, my lord, that the defendant number 1 and 2 stands has not been taken, has not been pleaded also.
Why should I read that?
The injunction,
You should not plead. What are you saying?
My lord,
Very funny.
no, my lord, I'm not.
Very funny.
Don't, my lord, my lord, don't subject me your lordship anger, my lord, don't
No,
subject
no,
me
it's
your
very funny. You are laughing at his submission.
No, my lord, I'm not laughing, my lord.
You are, first of all, it does not penetrate your head what he's saying. And you are being sarcastic at him.
I'm not doing
No, we
so.
are not even angry at you. We don't feel you to be sufficiently entitled to our anger. He's pointing out a relevant factor and you are ridiculously, sarcastically laughing at him. The defendant numbers 1 and 2 injunction sought against them. You don't disclose their stand. It's a material suppression. Don't even understand what he's saying and you are laughing.
I'm not looking, my lord.
You don't disclose. Defendant number 1 and 2 stand is very relevant here. Non-disclosure is suppression of material facts. Do you now understand why he's saying this?
No.
Have you disclosed your order 1 rule 10 application and this order?
No.
You are dismissing the appeal for suppression of material facts. Sorry.
Subject to my lord, this appeal, my lord, I have not.
Learned counsel for the respondent points out that apart from non-impediment of several other parties to the suit in the appeal, certain relevant facts have been deliberately suppressed by the appellant. For example, the appellant itself had taken out an application under Order 1 Rule 10 of the Code of Civil Procedure in the suit, in which the injunction impugned order of injunction was passed, seeking to be expunged from the array of parties on the specific admission that the appellant does not have any share in the suit property. Such application, however, was rejected. Be that as it may, it is pointed out that after taking such specific stand, it is doubtful as to whether the appellant has any locus standi to prefer the appeal. Next para, it is further submitted that the injunction was sought primarily against the defendant numbers 1 and 2, whose stand in the trial court has been suppressed by the appellant before this court. Next para, at this juncture, learned counsel for the appellant seeks leave to implead the necessary parties to the appeal. Next para, in view of such prayer, leave is granted to the appellant to make an appropriate application for addition of party with an advance copy to the appearing respondent. Next para, affidavit in opposition, if any, to the to Can 1 of 2026 shall be filed by the respondent within 3 weeks from date. Reply thereto, if any, shall be filed within a week thereafter. The application shall next be listed for hearing in the monthly list of October 2026. Get angry at people.
My lord, I'm appearing for the petition. I'm led by Shaunak.
My lord, may I have my lord's leave to appear virtually, my lord?
Yes, you are for the
For the appellant, my lord. Yes, for the appellant.
Number 3, 8, 9, and 11. Other respondents have been, my lord, substituted.
Other respondents
have been substituted. My lord, the Bhogalatnama has just arrived, my lord. I will file.
Oh, yeah, you have to appear for the others also. So file it during the course of the day.
My lord, in the event, my lord, I have two prayers, my lord. My lord, the Can 1 is ready for hearing unless respondent number 6, whose legal aids have now been substituted, my lord, unless they want to file any.
No, you are appearing for them.
It's been served by on the advocate, my lord. I believe they've accepted.
So Mr. Chakravarti has instruction to appear for them also. So we can pick up.
And service has been done, my lord, upon the previous advocate, who is appearing for other respondents.
That service has been effected.
That has been effected.
No, you have instruction to appear for the other respondents also, apart from 389. So very well, fine. Then
Yes, my lord, there was a direction for them to file an affidavit if they don't wish to, my lord, that can be recorded. Yes, my
same
lord.
family members, same documents, or
No
nothing
difficulty.
new, nothing new is required to my lord brought on record. My lord.
My lord, here, my lord, can 1 is for injunction, my lord, where we've already obtained an ad interim order of injunction. Can 2 and 3 have already been disposed of. Now, during the pendency of the appeal, my lord, can 4, we've taken out a subsequent application which we filed today, and my lord, we're going to serve it upon them today itself. My lord, during the pendency of the appeal, what has happened? My lord, they have put up hoardings and billboards on the subject property, my lord, whereby they're trying to alienate. That's also substantiating our ground that there's a real threat of alienation, or rather disposing of the suit property, my lord. The suit is for specific performance, declaration, specific performance, and injunction. My lord, will kindly have a look. My lord, here, my lord, may I just indicate, would it be my lord's pleasure to have can 4 on record and thereafter have the entire matter disposed of,
Yes,
or my lord, once?
Can 4 page 15, we are looking at those photographs.
My lord, can 4 has been filed today itself. My lord, it wasn't appearing in the list. I wasn't aware. My lord. I don't know if that's been served upon my learned friends, because it's been affirmed and filed today, I believe, subject to correction.
Oh, the application has come, but it's not appearing in the list. So you serve copy on Mr. Chakraborty then also.
My lord, will kindly keep it tomorrow, then we can have the entire thing. It's an additional, only an additional fact that's there.
You'll be able to get ready, Mr.
My
Chakraborty.
lord, this is another, my lord, attempt to, my lord, defer the matter because you are.
No, no.
My lord, I will show your lordship, my lord, from the judgment of the interplay that suit is not maintainable and no injunction can be granted at this stage.
May I just indicate what the suit is there? My lord? If my learned friend is opposing that, may I just
Suppose we
indicate?
go through this application and come back tomorrow. We'll take it up tomorrow only.
My
Tomorrow we take up the specially assigned matters first. Let it be in the list. Whenever we can, we'll call it.
My
Very well. Can 4 of 2026, comma, which has been filed today by the appellant, comma, be listed tomorrow along with the other applications. Push up a copy thereof is served. You are serving copy.
Yes.
Can-
Served, my lord, it's served.
A copy thereof is served here and now on the learned advocate for the respondents. Pushed up to enable the respondents to come prepared on the said application as well, comma. Let the matter be adjourned for the day. Affidavit of service filed today be kept on record. Push up learned counsel for the respondent submits that in view of the relevant papers having being already on record, comma, no further affidavit in opposition is required to be served. Push up, however, comma, it is recorded that the allegations made in Can 1 of 2026 are not admitted by the respondents.
My lord, the substituted respondents, my learned senior friend is now appearing for it. My lord, will kindly record that because respondent number 6 is
Already
deceased.
recorded.
As a leave is granted to the learned advocate for the appearing respondents to file vakalatnama for the substituted respondents as well during the course of the day. Thank you.
Deeply obliged, my lord. Deeply.
Number 19, Lordship, I appear for the petitioner. There's a direction to file the affidavit of service, Lordship. But Lordship, affidavit of service are not ready. But Lordship, we have filed a supplementary affidavit. Lordship, you could have really affirmed, and Lordship, kindly praying for one who said.
No, if the affidavit of service is not ready, there was a previous direction. And then you filed it on the next one.
As per the leave of this honorable court,
What about the affidavit of service?
It was not ready, Lordship. Kindly keep it one use time, Lordship.
Did you direct you to serve a copy of this supplementary also on them?
Yes, Lordship, supplementary affidavit also, and it was on the last occasion, Lordship. There is a leave of this honorable court, Lordship. The last order, Lordship. Sorry, keep one use time, Lordship, to come back to serve and come back before your Lordship.
Well, the affidavit, the supplemented affidavit filed today be kept on record. On the prayer of the appellant, the matter is adjourned till August 24, 2026.
Item number 20. 20, I am for the plenty. Appellant order 41, my lord, judgment of affirmance. I filed the suit against the state, my lord, on the ground that in terms of 14 years, I am entitled to 1 hectare of land. I am the Borgadar, since my predecessor. I am entitled to hold 1 hectare of land. You are saying that it has been vested, but I am entitled to do that. Both the courts made the same, my lord, mistake. Mistake is, my lord, they said that since your land has been vested under the Estate Acquisition Act, so therefore you are not entitled first, and second is that in terms of 14S, no civil suit lies. As against that, I am before your lordship.
Civil suit lies, we are.
Yes.
No, no,
regard to
does it
title.
lie? We are doubtful on that.
Yes,
Satisfy
civil
us on
suit
that.
with regard to 14X, my lord, it says that with regard to the procedure under which, my lord, the vesting process goes, that procedure with regard to any dispute with regard to that procedure, I cannot file a civil suit. But when, my lord, title is inheres in me,
Land Reforms
and they
Act.
are, my lord, the authority, they are denying.
How did you
And-
couch your
And
suits?
so far, my lord, estate acquisition is concerned, both the courts, my lord, made the
Land
same
Reforms Act,
mistake.
the
That
Land
is
Reforms Act.
initially, my lord, in terms of section 6, my lord,
আপনার কি মনে হলো কাকে বলছেন ল্যান্ড রিফর্মস একটা দিতে বাংলায় ওনাকে লয়ার কে Mr. Chatterjee, give us half.
Yes.
The regular officer he has suffered a bereavement in the family, that's why.
they are actually near agreement.
এটা কি দুটো বই আছে সেটা সেটা রিফান্ড আচ্ছা ল্যাম্পস এরকম বইটা এরকম এই কালার পার্টিকুলার শুরু করে দিই নাকি হ্যাঁ কিন্তু এটা আচ্ছা, let us see the frame of the suit, Mr. Chatterjee.
Yes.
The plaint prayer. How did you couch the suit? Whether it's
Suit
maintainable.
is, my lord, declaration and for injunction.
Now, have you got the annex the plaint?
No, my lord, plaint has not been, তোর কাছে plaint এর copy আছে? Plaint এর copy
Plaint is the most vital thing. Mr. Shabud is there on record. It's expected.
Everything I gathered, my lord, reading the judgment.
No,
এটা দে, plaint এর copy.
it's creditable that you have prepared yourself in the matter.
My suit, but there are
We
judgments.
require the plaint, Mr.
Yes.
Chatterjee.
That
That's
is
very.
I asked him, I didn't get as yet. Copy টা দে।
Already got it.
With regard to, yes, my lord.
Are you sure this is the plaint of this suit?
Let me check it up from the prayer portion, my lord. Yes.
If you have one copy, Mr. Chatterjee, as we do, we'll ask
No,
you
no,
to
your
choose.
lordship kindly see it.
If it's one copy, then you choose the judge and the other one will pass the judgment. That's your standard practice here. One copy you give to one judge and the other judge will pass the order.
Sorry, my lord. কাছে
Mr. Chatterjee, please come prepared with all the
Yes, my lord, I will take, my lord, all the books and don't worry, my lord.
not
Tomorrow
the
I will
books, the plaint also. The documents.
print as well as written statement. Why, my lord? One thing is that the point is very simple. Initially, what they said, my lord, that
Yes.
as per the Estate Acquisition Act, it has been since it was done, so therefore you have no
We have
title
to
over
see
this.
how the suit is framed, whether
Yes.
it comes within the bar,
Bar is there, 14X is there. I am reading.
whether the suit comes within the bar. We have for that.
No. Suit doesn't come, my lord,
That we-
according to so.
For that we have to see the plaint.
I-
here.
Yes.
Supplementary file
Supplementary. My lord, there is a supplementary affidavit I have filed in connection with the injunction. There, my lord, the copy of the plaint is there. আছে এটাতে।
Yes, now remembered. Mr. Shabud has now remembered.
Supplementary
আমার কাছে আছে।
Yes, it is there. You have a copy of that?
Yes, my lord. কোথায় আছে?
No, the first prayer, Mr. Chatterjee, you see, বাদীর পশ্চিমবঙ্গ ভূমি সংস্কার আইনের 14S2 and 3 মতে এবং by of adverse person. You rely on
Alternative claim for adverse poison.
adverse person. You are forgetting. You are
I'm
14S.
not on that.
You are relying on your right through 14S. How can it
Yes.
lie before the civil court? How can the civil court decide?
No, 14A says that I am entitled to acquire 1 hectare of land on the basis of the 1981 amendment. If that be so, my lord, 1 hectare is my land. So that the acts, my lord, give me that right, that I have the title over the same. I am reading, my lord, 14A. Your lordship finally come to 14A, your lordship will get it. What the law has given to me on the commencement of the provisions of this chapter or any subsequent date, any land owned by a Rayat in excess of the ceiling area applicable to himself vested in the state free from all encumbrances. Then my lord 2. Where any land vested in the state under subsection 1 is being cultivated by a Borgadar, the right of cultivation of such Borgadar in relation to any such vested land which, including any other land owned or cultivated by him, in excess of 1 hectare of land used for agriculture shall on the commencement of the provisions of this chapter stand terminated. Then every Borgadar shall in relation to the land which he is authorized under subsection 2 to retain under his cultivation become on and from the date of commencement of the provisions of this chapter a Rayat. So my
So
status
you
is
say
that
your
Rayat.
right is premised on 14S,
Yes.
but you are not seeking any relief under this act. Your right is premised.
Yes.
And what about B, Gha? Gha is that সরকার বাহাদুর কর্তৃক অধিকৃত হইলে you are entitled to compensation and all. B.
No, that is well at one point of time there was an acquisition proceeding that was going on. But subsequently they took it away under the Land Acquisition Act. I asked my client
No,
So
your
therefore-
Gha is that you are entitled to compensation.
No, but that I am relinquishing. I am not, because at the time there was a proceeding, rather they were in a position to initiate a proceeding under the Land Acquisition Act. So naturally, in my plaint I also incorporated it. Subsequently, they didn't start.
So
any
one ground was that civil suit is not maintainable. What is the other ground on which you took two grounds?
Yes,
What is
two
the-
ground why I am taking because they said both the courts made this, according to me, made the same mistake. They said that since the acquisition was under section 6 of the Estate Acquisition Act, so therefore you are not entitled to any relief. Difficulty is that initially what happened, under only the Estate Acquisition Act was there. Now there in terms of section 6, intermediary could have hold total 25 acres of agricultural land. Subsequently, in 1981, the third amendment came into operation. In terms of third operation, that right was also taken of the intermediary, only holding that only 1 hectare of land you are entitled to. I have only 1 hectare of land. What happened initially, therefore in my arrest record also, the land of my father or the grandfather, those were there. Now, after the arrest operation in the LR record, they are saying that it was done. So, if that be so, under the pursuant to 81 amendment, subsequently at the latter stage, the vesting took place. And there, I am entitled to 1 hectare of land. So, therefore, estate acquisition has presently no role to play here. Initially, Estate Acquisition Act was there, but after amendment, I have the amendment also. I am just reading it. 1 hectare. In terms of section 24 of the amending act, I am reading it. In section 14A of the Principal Act, in subsection 2, for the figures and word 1 hectare, the figures and words 0.4047 hectare of land used for agricultural land shall be substituted. Initially, and if your lordship kindly come to the Estate Acquisition Act, your lordship will find there 25 hectare of land. So therefore, out of that 25, my 1 hectare under the as the Borgadar, I retained under the intermediary. Subsequently, after 81, the intermediary's right was taken. আরে ওগুলো ছাড় না, তোর প্রসিডিং নিয়ে আমি কি করব? Appeal court said, from the certified copy of the LR proceeding, I found that yes, they have a good case. Unless the state is there, state will have to explain in which way, under their process, they acquired the same. I am in the statute gives me that right. I have become the direct tenant and rather right under the state.
Let us see the finding of the appeal court, Mr.
Yes,
Chatter.
madam.
It is a judgment of affirmance.
Yes.
So let us
affirmance.
see the
Of
finding of the
appeal court.
let us see the finding of the appeal court.
Yes. Relevant portion you also will find in our page number 8. Second paragraph.
Just
with regard to
courts,
that no civil suit light on
courts
that.
14x.
Yes. And then my lord, page number 9, third paragraph. Second paragraph. Section 14S3 is to say every Borgada shall, in relation to the land which is authorized by subsection 2 to his cultivation, become on and from the date of. In considering applicable aspect, I have gone through the certified copy of the order of the BLLRO in miscase number such and such. It appears that scheduled land was vested to the state in terms of section 6 of the Estate Acquisition Act. So it is needless to say that as per section 6 is an act that land is vested free from all encumbrances. This is the finding. Land Reforms Act came into operation.
Your predecessor was admittedly the Borgadar.
Yes, my lord. All along, under the Javindas my lord, CS record, RS record, everywhere my name is there. Only my lord, when in the LR record, my lord, we made an application for our recording. At that stage, my lord, they said that no, the land is vested. Then the proceeding started.
Section 6, why do you say not does not apply?
Yes, your lordship kindly come to section 6 of the Estate Acquisition Act.
Estate Acquisition Act, yes. You fell within the exceptions.
No, section 6.
6, yes, estate acquisition.
D, my lord. Section 6, 1, A, B, C, D.
D.
Agricultural land in his khas possession not exceeding 25 acres in area as may be chosen by him. That is the intermediary. How much he could have, my lord, withhold after giving the return.
Yes.
This, my lord, 25 acre, after the 81 amendment, the third amendment, 81, it became only 1 hectare. So therefore, that 1 hectare also in my case, I am saved. Rather, my total area of land is 1 hectare, of which
So
my lord, I am
you
the
claim
Borgadar.
you are the Borgadar, you claim under that intermediary.
Under that intermediary. So initially, if it is under the Estate Acquisition Act, then also my lord, I am entitled. And if it is my lord, under 14 years, then also I am entitled.
সেকশন 6 অ্যাপ্লাই করছে কিনা section 6 একটা স্টে কমেন্ট করে দিন section 6 was argued by any of you?
No. It is the court's finding. I do not know how my lord it was. And even it is expertly, my lord, judgments. Both the judgments are expertly because the state didn't contest.
Your suit was dismissed expertly by
Expertly. Quite unlike my lord.
understandable. This appeal will be heard on this second appeal will be heard on the following substantial questions of law. 1. Whether, in view of the plaintiff stroke appellant plaintiffs stroke appellants having claimed title on the merely on the strength of section 14 capital S of the West Bengal Land Reforms Act 1955 and not sought any relief within the contemplation of the said act, both the courts below substantially erred in law in holding that the suit was barred by section 14 capital X of the said act. Roman 2, whether, in view of the pleadings of the whether in view of the frame of the suit, the courts below substantially erred in law in applying the parameters of section 6 of the West Bengal Estate Acquisition Act 1953, which were not applicable to the case at all. Any interim relief you have?
Yes, my lord, I filed an application for injunction because my lord, already I am in possession of the land.
How do you get that you are in possession? Did you get any injunction in the trial court?
No, but nature court injunction.
Was there in
No. I am since we are still cultivating. That is true.
But we have to,
I made it clear knowledge in my application also.
it's recorded in whose name?
Means Bengali 1356 was.
It is recorded in your name. It is recorded in your name.
No, in the LR record, our names are not there. On the
Then how
basis of
can
the
we
RS
protect your position,
Yes,
Mr.
I know that, but with regard to Malad, the land Malad, let an order of status quo be there. I do not know what is in the position, so it would be better, Malad.
The respondent shall remain restrained by an order of injunction from creating any third-party interest and or encumbering the suit property in any manner during pendency of can 1 of 2018 within bracket old number can 3852 of 2018. Which of the appellant shall serve copies of the application on the respondents indicating that the same will next be listed after the timeline of filing affidavits is over, comma, before the appropriate learned single judge having determination, push up, affidavits in opposition shall be filed within 4 weeks from date, push up, reply thereto, if any, shall be filed within a fortnight thereafter. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. The trial court records shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of informal paperbooks without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. This much. Thank you.
Your Lordship framed the substantial question 14x also, I believe.
Yes, whether in view of your having claimed title on basis of that and not asking for any relief under that, courts below erred in law, substantially erred in law in holding that the civil suit is barred under section 14x.
Obliged to
I am for the appellant.
Yes.
My lord, all the defects have been removed. Last
Certified copies have been.
Yes, I have got certificate. I have annexed it. I have filed it certificate copy.
Let us see whether the office report is there.
I am for the respondents, Lordship.
Right. Office report are kono dayni. Anyway. So this is a judgment of affirmance or what?
Yes, my lord, kindly go through the judgment, your lordship. Where a controversial notice was issued.
No, trial court
Against-
certified copy টা কোথায়? ফাইল হচ্ছে বুঝছি আলাদা করে রয়েছে এটা ঠিক আছে হ্যাঁ এটা আছে
Plain case is discussed from page.
Yes, sorry, what is your it's a judgment of affirmance or reversal?
Yes, my lord.
Yes means both cannot be yes. Affirmance.
Yes.
You are the plaintiff.
Yes, I am the appellant here in this matter. I am the plaintiff.
You are the plaintiff in
No,
the trial court.
no. He is the plaintiff.
What was the suit for?
The suit for, my lord, is a title suit, but a suit for eviction actually. I am evicted on the basis of the title suit. But
Please take a seat, Ms. Yes. What is the suit for? What are the reliefs sought in the suit?
my lord, the suit was filed by them regarding, my lord, I am the tenant and they are the landlord. Landlord file a title suit.
Title suit?
Yes.
They ask for declaration of the title.
No.
How can it be a title suit then?
That is the thing, your
That
lord.
is the thing.
So that is done by
Got the thing, not that.
No, that is done by the landlord.
Let us see the plaint.
Yes.
Sandeep.
I don't have that plain right now.
Oh, you don't have the plaint also? How did you draft
no.
the memorandum?
My lord, actually, I'm very sorry to say, my lord, I drafted this, my lord, appeal through my lord, title app from the title appeal. But I don't go, even I didn't obtain that copy, my lord.
We marvel at your brilliance. How could you do that?
See your
copy of the plaint.
Anticipation, my lord.
We are lucky that you are giving even one copy. You are not supposed to give any copy. He is supposed to give copies. It was decreed on what ground, Ms. Mitra?
Only on notice ground, Lordship.
But that's a controversial.
Defaulter.
It was reasonable requirement was held in your favor.
Partly decreed, Lordship, 106, Lordship, they did not deny the
108.
106 of Transfer of Property Act, Lordship.
No, this was not under the Premises Tenancy Act.
No.
No.
You have taken reasonable requirement also as plea.
Lordship, addition, alteration was there, Lordship.
Only MOP we find. MOP is under section 108.
And I served notice under section.
You also filed the suit under reasonable requirement for reasonable requirement and default and all these things.
Well, a suitors decreed on the ground of default, Lordship. I served notice under section 106, Lordship, that was not denied.
So why was it dismissed then? Partly decreed.
Partly decreed.
What part was decreed?
Lordship, on the notice point.
Notice point means?
Notice point means I already served on the ground of default. Default, well, they did not deny the infirmity or validity of the notice, Lordship. After amendment of title transfer of property act.
Sir, Ola Rojok and Ranjit Rojok is the same and the identical person. I am paying the rent in the name of Ranjit Rojok. I am not defaulter, my lord. But they have issued a notice on 24th of January.
Ms. Mitra, take a seat, we'll hear him. Yes, yes.
Or they have issued a notice on 24th of January 2017 with regard to eviction. But situation is this, my lord. But
it was decreed outright. Yes. The suit was decreed. Reasonably page 8. In instant suit property panchayat area board Constitution apply করছে না section 106 এর notice legally valid notice ছিল বলে 106 ওটাকে কনস্টিটিউট করে দিয়ে দিয়েছে. Yes, what is your ground in the appeal?
Not because I am not defaulter. I am paying the rents from the very beginning.
This was decreed under section 106 of the Transfer of Property Act.
Yes, my lord.
On an issuance of a notice, a transfer act din to.
Kindly go through, my lord, the
Thank you. They are merely required to give a notice ending with the month of the tenancy, 15 days notice. Now, under the current 106.
Yes, no, that should be done. If the service of notice is proved,
nothing remains.
Is it required to? But that is a controversial notice, my lord. The notice not with regard to my lord eviction, but with regard to payment of rent. But I am not defaulter.
All right, show us that notice. Notice
is not with me, my lord. Actually, notice is not with me. Because I have drafted this appeal without the copy of this.
You don't have the notice. That is your only ground.
You don't have notice.
How do you know? You are submitting before a court of law. Before the High Court of a state. That the notice was only for recovery of rent.
Yes.
And you have not seen a copy of the notice.
Yes, I am obtaining the certified copy of
How do you have this guts to appear before a court and boldly say the notice was not for eviction, but only for recovery of rent? If you have not seen the notice, sir, how do you have the audacity to come before a court and say this, submit this?
Because
you have not seen the notice, sir, as an advocate.
Yes.
How can you submit before the court that it's not a notice for eviction?
Why I am taking your losses, I tender my apology, my lord. Because in the learned code below, it has said that it was not the notice for eviction. It's a notice for rent.
Have you got a copy of the notice? You also argue their point, Ms. Mitra. You are doing everything else. You also argue what point they have. What is their best point? You do that also.
Well, 15 clear this notice was there, Lordship. After an amendment of section 106, Lordship.
Yes, yes. এখন তো 15 days notice. The ending of the month. There is nothing in your appeal. What is your ground? Formulate your substantial question of law.
Because because I don't see the notice, my lord. If my lord,
You have not seen the notice is the substantial question of law.
no, my lord. If I my lord,
What is your question of law? On which ground should we admit the
in this
appeal?
case, my lord, because I am the dispute between landlord and tenant.
That we
I am
know
a
by
tenant.
now.
So I am paying the rent, my lord, since 2017, my lord. Just filing the suit.
Very well, we are dismissing your appeal. The present challenge has been, the present second appeal has been preferred against the judgment of affirmance, whereby both the courts below decreed the eviction suit filed by the plaintiff respondent on the ground of issuance of notice under section 106 of the Transfer Property Act 1882. So next para, learned counsel appearing for the appellant submits that the notice in question was one alleging default in payment of rent, puts up in the absence of any proof in that regard, comma, the courts below acted without jurisdiction in decreeing the suit. Puts up next para, it is further submitted that since the ground of default was not established at all, comma, the courts below erred in law in passing the decree. Puts up next para, a copy, although learned counsel for the appellant fails to hand over any copy of the notice in question, comma, on our request, comma, learned counsel for the respondent hands over such copy to the court.
As well as the plaint.
As well as a copy of the plaint. Full next para, contrary to the submission of learned counsel for the appellants that the suit was one for declaration and eviction, comma, we find that the suit was simpliciter one for eviction. Full next para, from the notice dated January 24, 2017, comma, which was the premise of the findings of both the courts and was duly averred in paragraph 7 of the plaint, comma, we find that clear 15 days quit notice was given by dint of the same as envisaged under section 106 within bracket 1 of the Transfer Property Act. Full next para, as per the language of the said provision as well as settled law, comma, a notice of 15 days is sufficient to obtain an eviction of the lessee within the contemplation of section 106 of the Transfer Property Act. Full stop, no further default on the part of the lessee is required to be proved if the notice itself is duly proved before the courts. Full stop next para, thus, comma, although certain superfluous allegations of default in payment of rent, etc. were incorporated in the notice, comma, fact remains that the notice was the notice asked the lessees to vacate the premises within clear 15 days, comma, thus coming within the purview of section 106 within bracket 1 of the Transfer Property Act. Full stop next para, in such view of the matter, comma, we do not find any error either of law or fact in the courts below granting an eviction decree on such ground. Full stop, thus, comma, no substantial question of law is involved. Full stop. Accordingly, SAT 79 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can such and such is consequentially dismissed as well. No address to cause, urgent certified copies. We are keeping copies of these on record.
Yes.
Thank you. Next.
Number 22.
Yes, Mr. Bunik.
Yes, may I please?
You have seen the notice, sir?
No.
No,
Lord,
sir, not
this is a suit for my lord eviction of licensee.
License, no notice is required.
Yes, now my lord.
In better case.
Defendant case is, my lord, I am for the defendant. Defendant case is his tenant. He was tenant. Now, my lord, your lordship kindly remember last occasion, the issue has been framed by the learned trial judge on the ground on the point that whether the defendant is a licensee or tenant. Now, on that issue, my lord,
Lost in both the courts.
lost in both the court. Lord, the learned trial judge has opined that the rent receipt itself has not been proved properly, and second ground was taken that the deposit of rent by in a suit for licensee to determine the tenancy has not been done by the defendant. These 2 points have been taken.
Is
Now,
obviously
obviously, my lord. Now, the
that-
appeal court below has opined that the plaintiff neither proves the licensee and the defendant never proves the tenancy. Now, your lordship, kindly remember, your lordship has pointed out, I'm grateful for that page 9 of the appeal court judgment, whereby the learned court has stated that someone has to prove that rent receipt, because rent receipt LTI has been exhibited as E, and exhibit E. Lordship kindly sees the page 9 of the appeal court judgment.
Yes, yes. Only LTI was proved.
LTI was
But
proved.
the contents of the rent receipt.
Yes.
Interesting case. Why
Yes,
didn't you prove the rent receipt?
No, I have checked, my lord, the evidence, and I found that yes, that has been produced, that has been proved by the defendant himself. Now, your lordship, kindly, my lord, allow me to place the evidence, my lord, consequently. Lord, this is, my lord, the chief, and this is, my lord, the cross, and my lord, chief of the, my lord, defendant, plaintiff side first. I'm sorry, my lord, markings were there, my lord, unnecessary markings were there. Now, your lordship kindly sees the relevant portion is second page. That is the denial. This is the original plaintiff. PW1 was terminated as original plaintiff. That is, my lord.
No, but where have
Jamia.
Your evidence is required.
Yes, my evidence, my lord. Your lordship kindly sees.
Prove that
Not a fact that we issued rent receipt in favor of the defendant in lieu of the said rent. This is
already. Yes.
Now, your lordship kindly sees the PW2.
So they deny having issued a rent receipt.
Not only denied, your lordship kindly see the PW2 next.
Yes.
Muhammad Farid. He is, my lord, the son of the plaintiff.
PW2
PW2.
Muhammad Azad.
Muhammad Farid. Muhammad Azad, sorry.
Azad. Yes.
Lordship, kindly see the last.
Farid is his father.
Yes. Your lordship, kindly see the last sentence. Not a fact. This is the said rent receipt issued by my mother towards the defendant on seeing the said rent receipt. So this had been submitted to the plaintiff. That is why thereafter your lordship kindly sees.
So they deny that it's a rent receipt.
Yes. Now your lordship kindly sees the evidence of the defendant. Now this part has been my lord, omitted by the learned both the court below.
But we'll keep this on record.
Yes. Your lordship kindly sees the date first. 3rd of March 2014. Immediately after the evidence has been closed of PW2, thereafter that original defendant, then he was not surviving. He expired in the month of February 2015. Now, 3rd of March 2014, last Milord paragraph. This is the original Kacha rent receipt issued by the plaintiff to me. This is her LTI. She has endorsed them before me.
LTI is marked as exhibit E.
No, this is the original Kacha rent receipt that has been produced.
Production
that has been
is not
produced,
sufficient, Mr. Punik.
and that is why your lordship kindly consider this.
Only LTI you have proved.
Kindly consider this thing, my lord. The rent receipt has been produced. It has been stated by the original defendant. This is the rent receipt which has been issued by the plaintiff.
They don't say this is the
Yes. Your lordship can see. This is the original Kacha rent receipt issued by the plaintiff to me.
Where do they say that?
The last DW1, the last sentence.
That is DW1 saying.
Yes. So your lordship query was no plaintiff denied. That is why the handwriting expert application was filed.
Plaintiff clearly denied that any rent receipt was issued to you. You produce a Kacha rent receipt.
Yes.
You don't have the contents proved. You only have the LTI proof. The LTI is in the original receipt.
LTI has been proved with objection. LTI has been marked as an exhibit. Now the entire rent receipt has been, I say, this is the rent receipt, and it has been tendered, it has been issued by the plaintiff. Now the learned court below has only marked the portion with objection. That is why the handwriting expert application was made. Thereafter, handwriting expert was appointed. By that time, is the next, after 9 years, when the everything has been
Did you take this point before the trial court that you did not the first appellate court? We are sitting in second.
It is my case, my lord. I am a tenant, and this is my rent receipt.
Sir Phonik, you don't follow what you are saying. Without the contents of the rent receipt being marked, only the LTI being marked.
No.
What goes on record is only the LTI handwriting expert. Suppose it is substantiated, that is your LTI. But court cannot look into the contents of the document. Only your LTI is proved. This is my LTI.
I'm putting my question myself. What else, my lord, the defendant can do?
No. Defendant had to prove. Not that it's entirely the defendant's owners, Mr. Boni. The defendant had to have the exhibit, the rent receipt marked as exhibit. Whatever you choose to mark, that is marked.
No. This is not my. Your lordship kindly sees. This is the learned judge who has, my lord, only marked this, my lord, the signature as my lord, exhibit E.
Where is your chief? DW1 chief?
Chief, my lord, I did not get this.
In your cross-examination, how can the judge even mark something which you did not
This
produce?
is not, my lord, cross-examination. This is chief.
Acha, the chief then produced you only
Lord, your lordship knows, my lord, better than me.
The statement is very clear. This is the original Kacha rent receipt issued by the plaintiff to me.
Yes.
This is her LTI. She has endorsed them before me. The LTIs in the original receipt is marked as exhibit B.
These has been recorded by my lord trial judge. Since my lord, she has refused the plaintiff portion.
You have not stated the attending circumstances. You had to make a positive statement, Mr. Boni, that this is the rent receipt. Yes, this is the rent receipt.
This is the rent receipt. This has been stated. This is the rent receipt issued by the plaintiff to me. What else, my lord, the defendant can do? Since, my lord, your lordship kindly visualize. Plaintiff refused the entire thing. She refused that this is not the rent receipt issued by me. Now, I, my lord, produce the same, and I have stated specifically that this is the rent receipt issued by the plaintiff to me. Coupled with the fact, my lord, thereafter the application.
This point was taken before the.
Yes. That is why, my lord, this.
First appellate court, how was it? This.
Page 9.
We could get only the contents of the state rent receipts have not been proved. So, the original Kacha rent receipt. This is the original Kacha. Yes, sir. So, therefore, the rent receipt was proved. This appeal will be heard. Second appeal will be heard on the following substantial question of law: whether the first appellate court ought to have applied the provisions of Order 41, Rule 27 within bracket small a and small b of the Code of Civil Procedure in admitting the rent receipts which were tendered to DW1 and proved by him. Full stop. Second substantial question of law হচ্ছে whether the courts below acted in a perverse manner in overlooking the fact that in the teeth of the bald denial by the plaintiffs of the existence of any rent receipt, comma, since the rent receipts which were produced, tendered at the time of the examination in chief of DW1 and proved by him, comma, were germane for the adjudication of the lists and ought to have been admitted in evidence. Yes, what you are for the respondent?
Execution is pending. Execution number 31 of 24.
The occupational charge.
Operation, yes. And we'll keep the question of occupation charge open.
That has been awarded, my lord. If your lordship says, my lord, I can produce the, at the time of stay of, by the learned appeal court, 1,000 rupees was, my lord, awarded. 2024, my lord. Present time, present time. We are considering all things.
2 years have passed, so many things have happened.
11,000.
No, it was
Almost happened in between. So many things.
Your lordship kindly sees the order.
1,000 rupees. What is the area? Area and location.
239 square feet.
239.
Is it used for a commercial purpose?
No, no, no.
My lord.
239 square feet.
239 square feet.
1,000 is sufficient. You agree and we'll pass that order.
Well, on instruction, my lord, 10,000 to 11,000.
10,000, 11,000. 239 square feet.
Right.
What happens in 239 square?
Ground floor and my lord, Ristra municipality.
239 square feet.
Prime location, my lord.
What will you do with that property in the prime location? Anyway, very well. File your opposition. There shall be stay of all further proceedings in title execution case. What is the number?
31 of 24.
Title execution case.
31 of 2024 pending before the Second Court of Civil Judge Junior Division at Srirampur District, Hooghly, till disposal of Can 1 of 2026. Push up affidavit in opposition to the application shall be filed by the respondent. How soon?
My lord, third court.
Your third court, it has been written as third court, not second.
In the prayer portion, my
The
lord.
prayer portion.
Oh, achha, achha.
My lord.
But in the evidence we are seeing, looking at the evidence, it says second court.
So that is that perhaps not transferred. Yes.
Page 7, my lord. Page.
And the
Stay petition, page 7.
if you say it's third court, you say third court. Third court. Civil Judge Junior Division Additional Court passed the judgment.
Now we not the pending before the learned
The
civil
rest
judge-
remains the same, only third court.
Third court.
Ota third court thala golo. Affidavit in opposition, if any, shall be filed within a fortnight from date. Reply thereto, if any, shall be filed within a week thereafter. Full stop. Liberty to the parties to mention the application for inclusion in the list before the appropriate learned single judge, then having determination after the above timelines for filing of affidavits are over. Full stop. Next para, it is made clear that the question of imposition of occupation charges and the quantum thereof is left open for being decided finally at the disposal of the stay application. In view of the appearance of the plaintiff respondent to her learned advocate, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a fortnight from date. The appellants shall prepare and file the requisite number of informal paper books without comparing the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Next.
All denial court.
Well, last occasion, my lord asked my other side to whether the matter will be sent to the landed court below for admitting the appeal, or
My lord, of the view, my lord, that
admit here.
notice should be issued to the learned advocate who allegedly gave consent, my lord. And because it is a partition final decree in a partition suit passed on consent. And,
Oh,
and
so you should have approached the trial court then, saying that no consent was incorrectly recorded.
the bar of 96 is also there.
Verbally.
96 bar is
That-
also
that is
there.
my sub-
But I preferred appeal. I preferred appeal, that is
Appeal
kind
is
of
not maintainable.
Appeal will be an illusory remedy.
Yes, that's why.
Because the appeal court does not know what happened there.
No.
You have to approach that court with a
That
proper
court.
application.
Court has recorded the consent. That's why my sub-
but what
If you say that consent was
the
not
other,
given,
the ground is there, my lord, without
consent decree, no appeal lies under section 96.
but
the bar is there.
my lord knows the consent, my lord, given by the advocate. We have no objection. Both sides. Well, kindly see the order dated 20th May.
But
What
that
happened here,
advocate-
my lord?
That advocate,
After so many years, the learned advocate filed commissioner report without serving copy to me, and the learned court below, my lord, accepted it. And my lord, at the time of hearing, learned lawyer, both the parties to the suit verbally submitted.
Difficulties, concession on law is not binding, but concession on fact is definitely binding. Unless you prove before the court that no such consent was given.
Verbally submitted before me that they have no objection.
Otherwise, there would be no meaning to the bar to a consent degree. Section 96
Well,
reverse consent degree appeal.
From that, I have a right to challenge the preliminary final degree on the ground that there no commission report was sub.
No, you don't. If it's a consent degree, you don't. You don't. That's a difficulty.
I think it is not consent actually, my lord, the verbally, my lord,
on the basis of this, my lord, order of decree
suit
was passed.
verbally submitted before me.
Last portion, can you see, my lord?
Verbally submitted.
No.
This is not the, my lord, the litigant
No.
instructed.
This is a clear concession.
The bar is abstracted. What is abstracted?
On a factual aspect, advocate has the
Actually, only, my lord,
that the advocate has the
Hajira was filed since the long pending matter. My lord, no copy of the
cannot prefer an appeal against that. That is what we are saying only. Section 96 clearly diverts. There is no appeal against the consent.
Yes, the consent is there.
Settle.
That
Even
is
look at the law
admitted.
even. No appeal lies against the consent decree.
Consent decree থেকে lie
Not on merits or this or that. No, at the threshold, the appeal should be dismissed.
আমাদের ওখানে আবার recall চাইতে হবে যে আমরা consent দিই।
ঠিক আছে সাহেব আপনি এখানে একটা করে দিন বলো আমি section
96(3) is unequivocal and
No,
unqualified. No
Unqualified.
appeal shall lie from a decree passed by the court with the consent of party.
There is no dispute
Whether
about
there was a consent or not, for that you have to approach that court only. That no consent
By the
valid.
same
consent.
advocate, but they are filed this appeal by separate advocate.
no.
Knowledge is of
No,
that
no, I
particular
have changed, my lord. When no instruction was given to me, and I, my lord, heard the result of the, my lord, suit from my brother. Since we are, my lord, residing same premises, whispering was there. They got
We'll
the
give you
decree.
liberty subject to limitation to approach. It's not too far away. I mean, only May 2025 this was done. And in the meantime, you take advantage of section 14. You can.
Huh,
You have to
that-
approach that court only.
Initially, my lord, order 9 rule 13 was filed before the London Court Bureau. That was withdrawn, my lord. And we filed appeal before the London appellate court.
Order 9 rule 13 period
Mr.
cannot be
Chief,
controlled.
And yes. No, that is withdrawn, my lord. That is withdrawn.
Yes, so that period your limitation ran.
But first time I came to know from my brother that they got degree from the court below, and thereafter I, my lord,
You were represented through advocate. First time, what do you mean by first time?
but no, my lord.
Then every litigant, now your client will go outside and say that whatever you said
Here
was
what-
not authorized by
Here
him.
what happened, my lord?
It will set a dangerous
We are
trend.
residing same premises.
We have to
my lord.
protect our advocates also, no?
But we, my lord, came to know from my brother that the degree has been granted.
You
by the-
submit this, tomorrow your client goes out, engages some other advocate before the Supreme Court, says my advocate, whatever he said, I did not authorize it.
That's why, my section 5, my lord, with section 5, we approached before the London appellate court.
my section 5 rejected.
Appeal
Only,
did
my
not
lord, 2 month, 8 days delay was there to prefer appeal.
Section 5 was dismissed.
Dismissed.
But
That's why.
we will hold that the appeal itself was not maintainable. We will give you liberty to approach the trial court for with an allegation that the consent was incorrectly recorded. No consent was given.
That is the allegation.
ওইটা করা যেতে
If you
পারে।
if you
My lord,
file, if you
only thing,
approach
my
the
lord-
trial court, and trial court will decide it
Yes,
in accordance with the
I agree with my view, my lord's view, but
Not our view, this is a law.
Law, this is section 96, my lord. My lord, meanwhile, my lord, execution case is, my lord.
Whatever, we
differ, my
approach
lord.
that court. The present second appeal has been preferred against
Section 96 bar হয়ে
a judgment whereby the learned first appellate court dismissed an appeal preferred by the pleasant appellant as time barred, comma, by upon rejection of the connected condonation application. Which of next para, learned counsel appearing for the appellant submits on instruction that although no consent was given to the learned advocate conducting the case for the appellant in the trial court, comma, apparently the final degree of partition impugned in the appeal was passed by recording consent. Full stop. Next para, from a bare perusal of the judgment accompanying the final degree, comma, we find that the learned trial judge recorded that at the time of hearing, learned lawyer of both parties to the suit verbally submitted before the court that they had no objection against the report of the commissioner and had prayed for accepting the same. And considering such verbal submission of learned lawyers for both parties, the court perused the case records and materials on it and observed that the plaintiff had prayed for drawing final degree on the basis of commissioner's report, and since there was no objection, comma, there was justification to allow the prayer. Full stop. Next para, section 96 within bracket 3 of the Code of Civil Procedure clearly debars any appeal from a consent decree. Full stop. Thus, comma, irrespective of whether the first appeal, title appeal was time barred or not, comma, the same was not maintainable in law. Full stop. It is trite law that in the event any of the litigants has any dispute to the recording of what transpired in a particular court on a particular day and or consent having been actually given, comma, it is the self-same court, comma, preferably during the concerned judge is still in the said office, comma, to approach the said court ventilating such grievance. Full stop. However, comma, no appeal is maintainable against a consent decree. Full stop. As such, comma, we decline to interfere under we decline to admit the appeal under order 1411 of the Code of Civil Procedure. Full stop. In the event the appellant is otherwise entitled in law, comma, it will be open. Nothing in the present dismissal shall debar the appellant from approaching the trial court which recorded the consent, comma, disputing the same. Full stop. If so approached, comma, subject to the law of limitation, comma, and upon giving opportunity of hearing to all concerned, comma, the learned trial judge may decide the same in accordance with law. Is there any connected application?
No. Yes, my lord.
Can one of 2026 is consequentially dismissed?
Well,
as
another
orders to
thing,
cause
my lord, the
certified
learned, my lord,
Trial
appeal court,
judge.
my lord, heard the, my lord, preliminary degree substantially. And now he promoted to, my lord, the additional district judge and heard the appeal.
Admission.
If appeal is not maintainable, the trust না।
আজকে ডেটটা চেঞ্জ করে নিল কেন? আগের দিন তো অন্য ভিউ ছিল, আগের দিন তো অন্য ভিউ ছিল, আজকে ভিউটা চেঞ্জ করে নিল।
24, my lord, I am for the appellant.
You're for the appellate.
Yes, my lord, an application was taken out, my lord, being canned to, my lord, in pursuant of your lordship's, my lord, last day order, my lord. That, my lord, an appeal was preferred, misappeal was preferred, my lord, erroneously, and my lord, the appellate court, my lord, dealt with the matter, my lord, on merits and not, my lord, on the ground of pecuniary jurisdiction. Therefore, my lord, my lord, annexing the certified copy, my lord, the application has been, my lord, taken out. We have challenged, my lord, the parent order of the suit, my lord, in the appeal itself, in the miscellaneous, my lord, in this appeal, and, my lord, the order of, my lord, the appellate court, my lord, has been, my lord, annexed here too.
Oh, you prefer the appeal against the
parent
that
order.
the parent order.
The
Before
parent.
the district court first.
Yes, erroneously, my lord. The suit value is 36 lakhs and not, my lord. The misappellate court, my lord, rather than, my lord, dismissing on point of jurisdiction, my lord, dismiss the same, my lord, on the ground of merits.
So now you are challenging the main order.
Main order.
So let us look at the main order.
Yes. So the instant appeal has been, my lord, preferred against an order, my lord, by which, my lord, the ad interim injunction has been, my lord, refused. Now, the ad interim injunction is in the nature of, it's a money suit, my lord, for recovery of money, and, my lord, declaration valid and permanent injunction. Now, my lord, may I take your lordship to the prayers first of the, my lord, the suit and also, my lord, of the injunction order.
First, let us see the impugned order once, and then we'll go.
Yes, yes.
8th of April.
April order, my lord, kindly please. May I take your lordship? Record is taken up for hearing of a petition filed by the learned advocate for the plaintiffs, praying for an order of interim injunction. Peruse the materials on record. Heard learned advocate of the plaintiff. No caveat is pending as per note of the Sherestadar. The contention of the plaintiff is that the defendant number 1 was earlier engaged as a maid servant in the plaintiff's house and has no relationship with the plaintiff's family members. After the death of the husband of the plaintiff number 1, the defendant number 1, showing herself as the wife of the deceased husband, as the wife of the deceased husband.
Why notice under section 82?
Because, my lord, the Indian Postal Department and, my lord, a few banks have been made a party where, my lord, the retirement benefits of, my lord, the deceased person, my lord, went through. The main, my lord, the allegation is that this person, my lord, the defendant of the suit, my lord, my lord,
claiming herself to be the wife.
Claiming herself to be the wife, my lord.
What have you produced before the trial court to show that you are the wife?
Yes. My lord, kindly sees. My lord, the deceased, my lord, Pinaki is the deceased, my lord. He died on 8th of August 2022. That is the case. Now, my lord, Dola was at that point of time, my lord, till 5th of April 2022 was married. Till 5th of 22, Dola was married. My lord, married to another, married to a different person.
In 15th?
Till 5th of April 2022. My lord, produced documents, my lord, the decree of divorce is annexed here too. On 5th of April, she obtained a decree of divorce and received maintenance till 7th of January 2024, long after the death of the deceased.
This is maintenance from whom?
Maintenance, my lord, from our previous
Earlier,
husband.
previous husband.
The erstwhile husband. Firstly. Secondly, my lord, kindly says, Dola.
That goes against you. Divorce decree have produced.
Yes. The decree of divorce have produced.
And what about marriage with this person?
Yes, my lord, marriage with me. Kindly take some, my lord.
No, who obtained you obtained a divorce decree?
No, Dola obtained a decree of divorce from our erstwhile husband. From a different person altogether. From a different person altogether.
Your marriage certificate or something?
Yes. My lord, I'll just, my lord, take your lordship, my lord, to a written statement.
Your husband died when?
My husband died on 8th of August 2022.
But before your husband's death, at least she had obtained the divorce decree.
4 months prior to the death.
So she might have married in the 4 months. We don't know.
No, cannot be, my lord, because I was throughout married, my lord.
Your marriage.
Never the case, my lord, that I was not married.
Show us your
And
certificate.
my lord, kindly considers one aspect. The appellant is not only my lord the wife appellant. The appellant number 2 is also the daughter.
Who in any event has, but that depends on your marriage because she's your
Yes,
daughter.
yes.
I'll just show us your prior marriage before 5th of April 22. That will suffice.
My lord, I'll just show my lord two things. My lord, Dola had taken out all the money, claiming herself to be the nominee, not the wife. My lord, I have obtained a copy from HDFC Bank, where my lord, the bank itself says that she was the nominee, and that's why we have disbursed us the amount. I'll my lord, take your lordship to that first, my lord. Kindly seize, my lord. Page number 309, kindly, my lord, takes up once. Page 309.
Is 09.
309. It's a 3-volume, my lord.
Yes,
application.
Yes, right.
309, my lord, is kindly takes up, my lord. Towards the bottom of the page, nominee is Dola Banerjee.
Yes.
And my lord comes to my lord page 299 once. I made a complaint to the bank. Page 297 it starts, my lord. It's an email, my lord, from the bank to me. Written statement
But where is your marriage certificate?
Yes, my lord, marriage certificate I cannot produce, my lord, since the marriage had taken place at a time when my lord certificate was not available.
When?
Long time back, my lord. I just
How long back?
My daughter is right now, my lord, 24 years old, my lord, of practicing.
So that is not so long back that your marriage certificates were not available.
I'll just
What was the year of your marriage?
I'll just, my lord, show one more thing, my lord. I'll just show, my lord, a written statement filed by Dola in a eviction suit, because she has also been residing in my property, where, my lord, she has admitted my marriage. She has admitted that.
Independently, you don't have any document. Which year? What is the year of your marriage? At least tell us that.
W is Purono W.
So, Banerjee, what is the year of your marriage?
I'll just, my lord, show that.
Don't have at least the date of marriage also you don't have.
I'll
It'll
just
be on your left hand side margin of your application in your notes.
Kindly, my lord, takes up the plaint itself, my lord. It starts at
the date. We are asking for the date only.
of November 1991, page 14.
Marriage certificates were very much available in 1991. Not so long back in history.
But my lord, kindly, my lord, takes up paragraph number 1 of my plaint itself, my lord. I've mentioned the entire details of, my lord, the marriage. When was the marriage, my lord, recorded? When was the register being case number such and such under the marriage registered office at Alipur?
This dismissal was at the ad interim stage.
Ad interim stage.
So has to proceed on your plaint. Is there anything on record? The bank cited the nomination only.
The bank cited the nomination only.
Where have they stated that? Page 297 is there.
My lord, kindly, my lord, takes up, my lord, paragraph, page number 224 once. 224, my lord, is my best case. (224) is, my lord, your lordship will get it, my lord, from volume number 3. Kindly takes up the first paragraph itself. It is the written statement of the defendant in a suit, my lord, of eviction. The plaintiff number 2 is the daughter of Mrs. Pinaki, who is the present husband of the defendant, ex-husband of the plaintiff number 1. Not a case, my lord, that the defendant is, my lord, denying my marriage, my lord. It's in respect of another suit, my lord. But, my lord, the plaintiff has admitted my marriage there.
A different suit.
It's a different suit. It's, my lord, in a title suit number 17 of 23, which is, my lord, an eviction suit.
By you against her?
By me against her. In the meantime, I came to know that she has, my lord, been withdrawing all the money from the different accounts, and that's why, my lord, the second suit was, my lord, filed. And, my lord, she has mentioned 16 TDJ of Alipur. I have taken out, my lord, an RTI application. 16 TDJ at that point of time was not available itself. There was no 16.
Dola says that Pinaki got an ex parte divorce decree against you.
Yeah, yes, from a 16th ADJ in Alipur.
What about that?
There is no 16th ADJ at all. In 2008, she says in 2008.
Now probably there is.
Now probably well, there is in 2008, 1st of January, 2nd of January 2008, there was no 16th ADJ at all. At least, well, my best case is, well, the plaintiff number 2, she is aware of the plaintiff number 2. The plaintiff, she cannot well, deny the claim of the plaintiff number 2. Prima facie, well, the plaintiff number 2 as a case.
What injunction are you asking?
Kindly sees, my lord, my injunction application, my lord. Kindly takes up the prayer, page number 89.
The withdrawing, transferring, otherwise dealing with amounts received by her.
Yes, because she has already received the sum of the amount, my lord. The learned trial court.
But there is still some amount in the account.
The learned trial court, the learned
You have not asked for injunction from her withdrawal. Oh, also restraining, yes.
Yes. The learned trial court says, my lord, that since she has already withdrawn, what is the point of injunction?
No, she has already withdrawn. The money doesn't have a name written on it.
Kindly sees, my lord, my first prayer. With regard to, my lord, my order 39(1) into application, my lord. I have also, my lord, prayed for an injunction from encumbering her for, or, my lord, otherwise dealing with the money received by her.
That's what we are saying. There is no name written in the money. Then the money. How can she not encumber? I mean, how can you enforce that? How can we earmark this particular money comes from that account and all these things?
Not at the stage of, my lord, a subsequent.
So, regarding what has already been withdrawal, that will be subject to the result of the suit of the injunction application. But further withdrawal, we may restrain.
Yes, okay.
Because you understand what we are saying. The money doesn't have a specific.
But, my lord, otherwise, my lord, at the end of the suit may prove to be futile. At the end, my lord, even if my lord, I have.
We appreciate that fully, but whatever has been withdrawn by her already, it's a money degree. It's a money degree you are asking
withdrawn by her, my lord, as a nominee. Kindly appreciates that.
Yes,
not
that
as a
money we cannot identify. This is that money she is spending. How can you enforce this order?
I cannot fully, my lord, get my lord.
And it's a money degree. Ultimately, it will.
Ultimately, it's a money. It's a money degree.
You have other remedies, but that we anyway. So the present appeal has been preferred against an order refusing the prayer for ad interim injunction made by the appellant in a money suit. Full-stop, the case of the appellant is that the appellant number 1, that the plaintiff stroke appellant number 1 was the wife of one Pinaki, whereas plaintiff stroke appellant number 2 is his daughter, was his daughter. No, he died.
Yes.
First up, subsequently, the said Pinaki having died, comma, the defendant number 1, comma, allegedly claiming herself to the wife of Pinaki, comma, withdrew certain amounts from his bank account. First up, next para, at this juncture, comma, the present suit was filed seeking recovery of the money withdrawn from the said account, and also seeking injunction restraining the defendant number 1, defendant stroke respondent number 1 from dealing with the amounts already withdrawn by her. Which of next para, learned counsel for the appellant points out that from the materials before the court, comma, it would be evident that a divorce that the defendant stroke respondent number 1, Dola, already had a subsisting marriage during the relevant period and obtained a divorce from her husband only on April 5, 2022. Full-stop, till as late as January 7, 2024, comma, there are documents on record to indicate that the respondent 1 got maintenance from her erstwhile husband. Full-stop, next para. Since Pinaki died on August 8, 2022, comma, even and respondent 1 respondent 1 received alimony from her previous husband even thereafter, comma, it is submitted that it will be evident that respondent 1 could not have been the wife of Pinaki during his lifetime. To sub next para, furthermore, comma, in a written statement filed by the respondent number 1 in connection with a different suit instituted by the appellant, comma, at least the fatherhood of Pinaki vis-a-vis appellant number 2, comma, the daughter of the appellant number 1, comma, has been admitted by the respondent number 1. So next para, from the communication between the bank and the appellants, comma, it would also be evident that the premise on which the bank released a portion of the amounts lying in the bank account of deceased Pinaki was that respondent number 1 was a nominee, comma, as opposed to an heir, comma, of late Pinaki. For sub next para, the learned trial judge, comma, it is argued, comma, although kept silent on the prima facie case made out by the appellant, comma, refused to grant injunction on the ground that no case of urgency or irreparable injury was made out and that no notice under section 80 80 of the Code of Civil Procedure had been served on the public officers, comma, who were some of the defendants. For the next para, it is submitted that the primary relief having been sought against respondent 1 and not the banks, comma, who were only proper parties and incidentally arrayed so, comma, no notice under section 80 of the code was required as such. For sub next para, from a perusal of the documents before the trial court, which are also annexed to the present pleadings, we find that that a sufficiently strong prima facie case for injunction was made out. First up, the very fact that a portion of the amount has already been withdrawn from the bank account in question furnishes extreme urgency. First up, in the event the entire amount is siphoned off prior to the disposal of the injunction application in the trial court, comma, nothing would remain to be adjudicated in the same. First up, next para, insofar as notice under section 80 is concerned, comma, we prima facie agree with learned counsel for the appellants that since the principal relief has been sought in the suit against the respondent of 1, comma, there was no question of prior issuance of a notice under the said provision on the banks and their officers. Full stop. Next para. We also take note of the fact that initially the appellants had filed within bracket erroneously bracket close a first miscellaneous appeal against the impugned order before the trial before the district court, which, comma, however, comma, was dismissed not on the ground of maintainability but on merits as well. For sub next para, since the learned who was that, the district judge himself or additional district?
No, it is my lord, additional district judge, first court, Barashat.
Since the learned additional district judge, first court at Barashat, prima facie heard in law and without jurisdiction in deciding the appeal on merits, comma, in view of the said court not having threshold jurisdiction to take up the appeal, comma, we treat can 2 of 2026, comma, filed in connection with the present appeal, comma, as a revisional application ancillary to the present appeal and admit the same as well. First up, the operation of the order impugned therein, dated, what is that order?
22nd of April 2026.
April 22, 2026, comma, passed in FMAT number, misappeal number 57, 57 of 2026.
Yes, sir. Yes, 57.
Shall also remain stayed till disposal of can 2 of 2026. For sub next para, the respondent number 1, the respondent shall remain restrained by an order of injunction from withdrawing stroke disbursing in favor of the respondent number 1 any further amount from the subject bank account. The details you have furnished.
Yes.
Subject bank account.
20 years.
No, not in the prayer portion. standing in the name.
My lord, kindly sees, my lord, the schedule. It starts at, my lord, page 46 of the plaint. Page 46, my lord, of my application. 46 and 47. my lord.
And or encashing any amount in respect of the fixed deposits, comma, as enumerated in schedules A and schedule B of the plaint of money suit number 279 of 2026 pending before the second court of civil judge senior division at Barasat district 24 Parganas till disposal of can 1 of 2026. Full stop. You have soft copies on the other side? No.
No, my lord, first one.
The appeal is accordingly admitted. Full stop. The appellant shall serve copies of both the applications and the memorandum of the appeal on the respondents. Which respondent? Only one?
No, my lord, the bench.
No, all the yes, we have passed injunction. Against the respondents indicating that the application shall next be listed for hearing in the monthly list of October 2026 when an affidavit of service to that effect shall be filed by the appellants. The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. Full stop. The trial court records need not be called for the present. The appellant shall prepare and file the requisite number of informal paperbooks without comparing with the records by incorporating all relevant documents within 6 weeks from date. Grateful.
Twenty-six. 25 and 26, my lord, similar orders
25, 26,
made by the City Civil Court.
I am appearing for the respondent, my lord. I am praying for 1 day accommodation. The item number 25, the copy is it I have received, and 26, they have served upon me. Both the matters are similar, that we are tenant of the defendants, and we have claimed for a peaceful positions injunction order, and we had.
What is the nature of the order?
Nature of injunction order was granted in our favor, and after that they have filed.
Yes, Mr. Tucker, what do you say?
1 day.
My lord, it has been served. They were on caveat, both have been served. Affidavit of service is there. He seeks a 1 day's accommodation, I don't mind, but it's a very innocuous order, but it restrains me and there's gross suppression. There's an agreement which is not disclosed. But I know your lordship's view, the view of this bench in my lord, this suppression also. But the agreement has an arbitration clause as an agreement, but without on that agreement, 26, my lord, is a lawyer. He uses it for his practice as his chambers, law chambers. I have some reservations, but the matter is such that I have to. I was thinking if it could be resolved, my learned friend can take instructions. They have it's a co-user space now. Your lordship is aware this is very common now that co-working space. There are chambers and office rooms built. So 26 is a lawyer. 25 I have no love loss, but 26 is a lawyer. He's using it as his practice area. And my client provides them tea, coffee, the regular services which are there. Now they have fallen out. It's come to litigation. If it can be amicably resolved, we can give them some time to vacate.
Take instruction on that also.
We are happy to give them a time to vacate. Otherwise, it has to be proceeded with. Because
so what do we do? We adjourn for a week or what?
No, not kindly not. Because after
adjourn for the day only.
Only adjourn because now they are pasting notices all over the place that we've got this order inciting other people.
No,
Kindly keep it tomorrow, Malaj. My learned friend can take instructions, whatever time they need. Because we cannot now live under the same roof. But if they want to fight it out, yes. But if they want to settle it amicably, security deposit will be.
There will be learned advocate for the respondents. Hearing of the respondent number 1. Sorry. Hearing of the appeal 10th adjourned tomorrow. Hey, what is adjourned to tomorrow?
Well, the only thing is tomorrow can't have some precedence. I'm told not precedence. Retain it.
We take up specially assigned matters first. It will be in the list.
Yeah, tomorrow there's some news of.
Tomorrow also.
Yes, because today's got deferred. Today was act of God.
Today's has been. Yes.
Today was act of God now.
That is also act of God, but
yes,
now it will be the act of the bar. The rest of it.
Both similar, both matters.
Yes, 25 and 26.
Grateful.
Please take কথা বলে না।
Yes, what is the matter?
This is a misappeal against an order of an interim order of injunction that in a money suit. My lord, the facts in a nutshell is that this defendant and her husband befriended with me and induced me to lend him some money so that they can
Come closer to the microphone.
invest it in their development project, real estate business, and they will return it back.
Give the property to you.
No.
You're the developer.
No, I have had some extra money. They induced me to lend them. So I lent 58 lakhs over a period of time. They returned me 34 lakhs by way of installments. I and therefore owe 24 and odd. My lord, there is no, it is an admitted fact, there is no formal agreement. However, bank transactions are there. Now, when the defendant, the husband died on 30th December 2024, and after that, when
Injunction regarding the property has been given.
Injunction refused has been. In this, there are certain properties.
After you get an injunction in a money suit, that will amount to attachment before judgment. You have to satisfy the tests of Order 38 Rule 5.
My lord, I am backed by one judgment passed by your lordship on the similar.
Yes, we'll say that that is a par imperium judgment. If it's our own judgment, we almost own it. Yes. 38(5) criteria have to be fulfilled. In a money suit, if you want an injunction regarding the immovable property.
There is, unless,
yes,
my lord, if you get the order, then what will happen? That is the thing.
Satisfy the tests of Order 38 Rule 5 that they're trying to dispose of the property to avoid a decree which may be passed.
But under Order 39 Rule 2B, the same principle is there.
Let us see this order.
CPC term. My lord, paragraph number 14, 15.
Let us read it.
Oh.
See para 15.
Yes, my lord.
Of this. Read it out.
We are aware that of the fact that in case as the present one, the test even for grant of injunction order 39 Rule 1 and 2 have to be on a higher footing, although less stringent than order 38 Rule 5, since the corporeal right of the immovable property regarding which injunction is sought is not the subject matter of the directly, but the suit has been
At case
filed in
35
one claim.
criteria were met.
My lord, kindly thereafter.
Don't even have a written agreement. An agreement
No,
was produced.
my lord, we have bank transactions. I
Invoices
can
were
satisfy your lordship.
No, that was for because goods had been supplied by them. Non-payment for goods supplied. So they had solid invoices which we considered bank transactions, written agreement. You don't have a written agreement, there is a question of invoice, you just plead a loan. No loan agreement, nothing. So how do you know even this property is a security of that loan?
Was also completely unreasoned one.
Order was also unreasoned one, completely. Suppose even this order is unreasoned. For the time being, let us say so. But there, it was a case of goods supplied, money not paid. The invoices for the goods were produced and a written agreement was produced. You produce precious nothing. Here you have supplied no goods.
No, nothing.
No agreement is there, nothing.
From over a period of time,
Bank
I
transaction
paid
showing
money.
that you paid money.
And they returned me a portion of money. Now, why they will
You
return?
have to only show that they are trying to dispose of the property, the immovable property.
Yes.
But we don't know whether this immovable property was a security for that money. The case made out in the other one, in this reported judgment, it was different. It was not some property as security of money. There it was goods had been supplied and invoices have produced. Agreement was there in writing.
No, yeah,
So
in
there
my,
we could ascertain whether there is a
no, it is an admitted fact that I don't have any formal agreement.
agreement. How do you know this property was a security for that?
No, it is not. At the time of my lord.
See, we will not interfere here. We'll permit you to file an appropriate application under Order 38 Rule 5. If you meet the tests, then court may grant. This will not prevent you from doing that. That much we can say.
One more thing I want.
Yes, absolutely, please.
Under Order 39, Rule 1B, my lord.
D or B?
B for Bombay. That the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditor. My lord, I am the creditor. It is an admitted fact. And when
Who
I...
admits?
Who
admits?
How? The
The
defendant.
admitted
As because when I...
Who admit that you are a creditor?
No. When I issued a demand notice, they have not replied it. It is they have not.
How the admission comes?
My lord, it has to be. They would have denied it, my lord. If the situation is that if they sat tight over the when I issued the notice. Now
This
they
was
have
interim refusal. Where did they have the opportunity to deny?
No, prior to that, I issued a demand notice. No reply had been.
Pleading. One can ignore it also altogether.
Whatever you have written in your demand notice or plain, that is your version.
But they have an opportunity to refute that. When I issued the demand notice.
It's not a pleading that they have to refute it. They may say nothing. Sit tight.
They sat tight over the issue, over that my allegation.
No loan agreement is there.
No formal agreement. That is the difficulty. No formal agreement is there.
Transactions are there. From the
Yes,
transactions,
yes.
what is evident? That you have paid money to
I have paid, they returned a portion. The remaining is due.
That payment of the money sought to be recovered
through bank transaction.
That entire payment from your end is shown.
Yes, some cash transactions are there, but 90% through bank. I have statement. Can your lordship can?
What is the amount which passed through the bank? You paid to him.
56 lakhs and 2 lakhs by way of cash. Kindly come to page, my lord. I have page 25, 26.
Yeah. Where have you pleaded in your injunction application in the trial court that they would dispose of the property or trying to dispose of? Let us see if there is an ingredient of Order 38 Rule 5 even in your application. Temporary injunction application you have not annexed.
That has been left out, my lord. I am very sorry. My juniors have left it out.
They should have left you out also outside the courtroom. They would have faced the questions of the court themselves. Those paragraphs, 10 paragraph.
My lord, para 10.
Yes, we have seen para 10. Reading is there. Very well. The appeal will be heard on the grounds taken in the memorandum of appeal. So next para, in a money suit filed by the appellant against the respondent, comma, the appellant sought an injunction restraining the respondent from transferring an immovable property belonging to the respondent, full stop. Before the trial court, comma, the plaintiff stroke appellant furnished bank statements to show prima facie at least that a substantial portion of the amount allegedly given as loan by the appellant to the respondent passed from the hands of the appellant to the respondent through the bank. First up, even the return of such a portion of such amount by the respondent to the appellant has been established from such bank statements. First up, thus, comma, a prima facie case of the appellant having granted an amount in loan to the respondent and the respondent having repaid a part thereof appears from the materials which were before the trial court when the ad interim injunction was refused. First up, next para. Furthermore, comma, we find in paragraph number 10 of the temporary injunction application filed in the court that ingredients akin to Order 38, Rule 5 of the Code of Civil Procedure have also been made out by alleging that the defendants, comma, after receipt of the demand notice, defendant, after receipt of the demand notice, is trying to sell the properties mentioned in the earlier paragraph to defraud the plaintiff so that the plaintiff shall not be able to recover his dues by selling the properties of the defendant. First stop, next para. In such view of the matter, comma, this court is of the opinion that the learned trial judge ought to have considered the prima facie case even on a footing higher than Order 39, Rule 1 and 2, and somewhat akin to Order 38, Rule 5 of the Code of Civil Procedure. First of next para, thus, comma, the respondent shall remain restrained by an order of injunction from selling, transferring, alienating, and or encumbering, as well as from creating any third-party interest in respect of the properties enumerated in paragraph number 9 of the plaint till disposal of Can 1 of 2026. First of the appellant shall serve copies of the memorandum of appeal as well as Can 1 of 2026 on the respondent, indicating that the application shall next be listed for hearing in the monthly list of October 2026, when an affidavit of service to that effect shall be filed by the appellant. The trial court records are dispensed with for the present. First up, the appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent within a week from date. The appellant shall also prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from date. Full stop.
Okay.
Thanks.
My lord, I'm appearing for the appellant.
Yes.
My lord, my first contention is that, my lord, this is an application
We asked you about the maintainability of the appeal since it is arising out of a miscase.
miscase.
What was the miscase under, Mr. Sinara?
This is actually section 30. It has been stated in the application. This is an application under section 34. But my submission is that, my lord, the entire cause of action comes within the section 92 of the CPC. In case of any alleged breach of any express, if this is a miscase, my lord, then our three-bench judgment, our High Court Honorable three benches judgment will cover, and my lord, I am to file a 227 under, and
that is why we asked you the question.
Yes, my lord.
File a revision.
And my lord, if this comes within the,
is it a public charity according to your?
Yes, my lord, I am dealing with the Devottar property, my lord.
It's a private Devottar property.
Yes.
Not a public charity.
Not a public charity.
It's a private trust, then it comes under the Charitable and Religious Endowments Act.
Section 7 na kota
Section
92
in the 92 miscase, registered as a miscase and being heard as a miscase.
Yes, but
give you liberty, go and file a.
My lord, actually, my lord, the parties also want to settle this, my lord.
Settle it. Don't file a revision, settle it. We are giving you the liberty, don't take the liberty. The present appeal has been preferred against an order of injunction passed in a miscellaneous case.
Oh, my lord, certified copy of the order impugned may be.
Yes, we'll do that. Where is the miscase? The application is there? Yes. Yeah, very well, it's there. Under section 34 of the Indian Trusts Act 1882.
Yes.
Which of next para, thus, comma, since such an order is not amenable to appeal, comma, appeal under order 43 of the Code of Civil Procedure, comma, since not passed under order 39 rules 1 and 2 of the code arising out of a suit, comma, the appeal is not maintainable. Full stop. Accordingly, FMAT 730 of 2026 is dismissed as not maintainable, with liberty to the appellants to prefer an appropriate challenge against the impugned order before the appropriate court/bench. Full stop. It is made clear that this court has not entered into the merits of the case. Full stop. Can 1 of 2026 is disposed of accordingly. The appellant, the learned advocate in record for the appellants is will be at liberty to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. Full stop. No arrest to costs. Urgent settlement.
My lord, I'm the applicant led by Mr. Tanmoy
I'm for the,
Yes, Mr.
the plaintiff is the appellant before your lordship.
You're
Milord, in a
celebrating a rainy day, Mr. Mukherjee, celebrating a rainy day from home.
not celebrating, Milord. My house is totally, Milord, waterlogged down.
Suffering a rainy day.
Milord,
Yes.
the plaintiff is the appellant before your lordship, Milord, in a suit for partition. Milord,
Yes.
in such a suit, Milord, there are several defendants. Milord, initially I got an order of injunction ad interim. Milord, upon satisfying the prima facie case. Milord, if your lordship takes up, Milord, can 1, Milord, the last annexure before your lordship, the order number 2, dated 3rd of April 2025, it's the order which I was enjoying, Milord. Milord, if your lordship now takes up the memorandum of appeal, this, Milord, at the time of hearing of the temporary injunction application, finally, this order has been, rather my application for temporary injunction is rejected on the premise that, Milord, there is a, Milord, defendant number 2 and defendant number 1, there is a contract with regard to, Milord, making of a passage by a strip of land which is a part of the suit property. That is a, Milord, agreement between defendant number 2 and defendant number 1, alleged agreement. Now, defendant number 2, Milord, has filed a suit against defendant number 1 for cancellation of that agreement in the year 2025. On that premise itself, if your lordship takes up, Milord, the last order number 6, my temporary injunction application has been rejected.
No, this property belongs to whom? The property on which this
property belongs to, Milord, all the parties to the suit.
You
Now,
and them, you and the defendants.
Yes. And there is an agreement, alleged agreement in between defendant number 2 and defendant number 1 for, Milord, making a pathway over a strip of land of the suit property.
You are not a party to that agreement.
Oh, no,
You
no, I am
purchase,
not.
you purchase subsequently.
I purchased subsequently, Milord, from the, Milord, defendant number 2.
All right.
Nevertheless, Milord, the filing of suit inter se between defendant number 2 and defendant number 1 for cancellation of that agreement cannot be a premise, Milord, for vacating of my order of injunction or rejecting, Milord, my temporary injunction application.
You are claiming through defendant number 2, your rights cannot be better.
Milord, the property is undivided. There is no dispute. That is inter se between defendant number 2 and 1.
So your suit is for? Your present suit is for?
For partition, if your lordship takes up my plaint.
What is the injunction? What is the injunction you sought, Mr. Mukherjee?
Milord, I sought, Milord, so that, Milord, no nature and character should be changed.
But wouldn't that militate against whatever order is passed in that suit? What is the injunction there?
No, Milord, there is no injunction, Milord, in that suit. In
Now,
that suit, there is no.
defendant number 2 asked for an injunction against 1.
Defendant number 2 asked for cancellation of that alleged agreement against defendant number 1.
Any interim order sought there?
No. And,
So
Milord,
there is-
suit property are also not the entirety. That's a strip of land. Milord, my learned friend is there, Milord. He can hand over the plaint of that suit. Your
No, we
lordship.
understand, Mr. Mukherjee. We are taking the worst case against you for the time being because you were hearing your expertise. And the trial court also heard your expertise. No, sorry, that was a
No.
contest.
Milord, it's there.
Anyway.
What?
Your partition suit also covers that strip of land also.
Yes, Milord, yes.
So, but there is no conflicting injunction passed in the other suit.
No. There is no subsisting conflicting order of injunction. It's only the suit that has been not filed and pending.
Let us see the impugned order one.
Yes,
Why?
Milord, kindly up Milord, the memorandum of appeal, Milord, the order number 6.
Oh, on the basis of that contract.
Yes, that contract. The pendency of the suit is there. So the learned judge is of the opinion.
Court also proceeded on that premise which we were proceeding, that you were bound by because you have
Yes.
purchased from him. You are not a party to that suit.
I am not a party to that suit, and Milord, even if Milord, the property is with regard to Milord, a creation of the Milord common passage or passage, that too over a undivided property.
Acha, Mr. Mukherjee, tell us that suit was instituted in 2025. When did you purchase?
Milord, my purchase, but may I just...
Before or after that suit? Tell us that only.
Yes, Milord. My purchase, Milord, is...
Take your time, but give us the date. Agreement was of 2015, long before your purchase. Must
yes,
be.
yes.
Or the suit we on. Their suit is 135 of 2025. What is the date of your agreement? That let us see. Sorry, your purchase deed. You also purchased in 2025 only, probably. Sorry. Yes. Para 7.
Para 7.
Those two defendants are contesting. They contested this injunction application.
The present injunction application, the written objection is being...
1. Oh, defendant number 2 is your husband.
Yes.
All right. He purchased, sold certain portions to you, his wife.
To me. The property is undivided. He purchased Milord certain portion to me. Sold out rather. Now, Milord, I filed the partition suit saying, Milord, if your lordship compare the schedule of these two, entire Milord property is the Milord hotspot of the partition suit.
So
Now
we can contemplate granting an injunction regarding the portion excluding that subject matter of the other suit. Because you have purchased through your husband. You have purchased through your husband, yes. Your husband is, there was a registered contract previously, that's sub judice before another court, but there was a registered contract.
Not registered, not a registered contract.
Court says that matter of the registered contract. In the
Milord, my learned friend is there, Milord. My learned friend can hand over the Milord copy of that Milord plaint. If your lordship takes up Milord that copy of the plaint, it's Ghoshona Patra, Milord, paragraph 3. It's a type copy, Milord, I believe, Milord, paragraph 3, if your lordship takes it up. And the entire bone of allegation is that, as per the agreement, the passage ought to have been, Milord, constructed in some other way, but he is contemplating to construct in other, Milord, portion of the property. That gives rise, Milord, to a cause of action for cancellation of that agreement.
No, Mr. Mukherjee, a number has been given. Apparently, it's a registration number. উভয় পক্ষের সম্পত্তি অনুসারে গত ইংরেজি 23/9/2015 তারিখে 2902 by 2015 নাম্বার একটি ঘোষণাপত্র প্রস্তুত করেন. Number would not have been allocated unless it's a registered document.
Yes. It ought, yes. I'm sorry, Milord. Yes. But it must have been the Milord registration number.
Yes, this should be registration number. It's put in an awkward manner, but has to be registration number.
But Milord, the premise on which the paragraph 3 suggests that instead of the place where Milord it ought to have been constructed, it contemplated to be constructed in a different portion, that gives rise for cancellation. Now, Milord, cancellation is a subject matter of that suit, no doubt.
Your husband has filed that suit. Your husband has, the other suit has been.
Yes. This suit filed by the Amirul. Yes.
Very well. So, your husband there's a registered contract between defendant number 2, your husband, and your vendor, and the other defendant number 1. Now, that registered contract is of 2015. Now, the court, the apprehension we find, there is some basis to the apprehension that you are trying to frustrate that the outcome of that suit by seeking an injunction that both the defendants, including defendant number one, who is a defendant in the other suit, they would be restrained from changing the nature and character. So that would preclude defendant number one and defendant number two from honoring that contract, if even otherwise, if the decree is passed in the different suit.
Then, Milord, your lordship can always pass an order of injunction suggesting that this injunction would be not subject to whatever order that will be passed, Milord, in that suit. Because that suit is, Milord, if your lordship takes up the plain schedule of both the suits, your lordship will get, Milord, the schedule of the present suit.
Or we can exclude the subject matter of the other suit from the purview of the injunction which we are contemplating.
Milord, in the other suit, there is no prevailing order of injunction. So with regard to, that's why, Milord, if tomorrow there will be any order that the parties, defendant number 1 and 2, may seek before that court, Milord, that order will not, Milord, preclude, Milord, or rather, Milord, this order will not preclude the parties to ask for anything, Milord, in that suit. That much, Milord, I can, Milord, say before your lordship, because the schedule of the property, if your lordship compare, these are two different. My lord kindly takes up page 21 of my, Milord, can 1. My
yes.
lord get
21, yes.
It's not entirety of the that 488, not the entire, Milord, property is 53 decimal. Now, if your lordship takes up, Milord, that suit plain, which my learned friend has handed over, that's, Milord, only restricted to plot number 1 plot, that is 488.
The other
kindly see.
No, both are both concerned 53 decimal. Oh, no.
No, point 0.25.
Yes.
That's where I am on, Milord. It's not that now the entire property, if it is undivided, even the defendant number 2 or defendant number 1 do not have, Milord, any right to give or to make agreement with regard to exclusive possession or making something, Milord, with regard to the exclusive, because the property, there are other defendants also. Milord, your lordship's, Milord, age-old, Milord, principle is that when a property is, Milord, joint property, undivided property, even a co-sharer do not have a right, Milord, to sold out or to make any agreement with regard to a definite demarcated
there are other independent co-sharers also.
Yes, Milord. My suit, Milord, there are, kindly see the plane, there are several parties, co-sharers. Not only me or my husband. So even they do not have, Milord, any right to give, Milord, or make agreement with regard to the specific demarcated portion of the property.
Yes, Mr. Mukherjee, you are right. The present appeal has been preferred against the dismissal of an injunction application filed by the appellant in a suit for partition, where the appellant is a plaintiff. For sub next para, learned counsel for the appellant points out that the injunction in respect of changing the nature and character of the suit property primarily was refused on the ground that a different registered contract allegedly executed between the defendant stroke respondent number 2 and defendant respondent number 1 is the subject matter of a different suit. For sub next para, the learned trial judge proceeded on the premise that since the defendant number 2 stroke respondent number 2 purchased a portion of his share in the property to his wife, comma, the present appellant, comma, the contract entered into between respondent number 2 and respondent number 1 is incidental to the property and is also binding on the subsequent purchaser, that is the appellant, who claims through respondent number 2. For sub next para, however, comma, it is pointed out that there are other independent co-sharers in respect of the total property who are not party to the alleged registered agreement, which is the subject matter of the other suit, comma, being title suit number 135 of 2025, pending before the First Court of Civil Judge Junior Division at Kandi District, Murshidabad. Which sub next para, thus, comma, it is argued that even if the said registered agreement is upheld and the suit filed by respondent number 2, comma, the husband of the appellant for cancellation of the same fails, comma, fact remains that only two of the co-sharers cannot mutually alter the nature and character of a particular portion of the entire joint property, comma, since all co-sharers have equal right over every inch of such property. Full stop. Next para, even otherwise, comma, it is pointed out that no interim order of injunction has been passed in connection with the other suit. Full stop. As such, comma, it is argued that the present partition suit proceeds on an independent premise as opposed to the earlier suit, where all the co-owners are not parties. Full stop. We find substance in such contention. Full stop. Accordingly, the appeal is admitted to be heard on the above questions and the other grounds taken in the memorandum of appeal. Full stop. Your prayer is against respondent number 1 only. The respondent number 1 only. Mr.
Yes, my lord.
The respondent number 1 shall remain respondent and his men and agents shall remain restrained by an order of injunction from changing the nature and character of the suit property in any manner till disposal of Can 1 of 2026. The appellant shall serve a copy of Can 1 of 2026 as well as a copy of the memorandum of appeal on the respondent number 1, indicating that the application shall be listed in the monthly list of October 2026 when an affidavit of service to that effect shall be filed by the appellant. Full stop. Next para, in view of the subject matter of the present appeal and the injunction application is restricted to the appellant and the respondent 1, comma, service of copies and or notice of the appeal on the other respondents is dispensed with for the present. Full stop. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent number 1 within a week from date. Full stop. The appellant shall also prepare the requisite number of informal paper books without comparing with the records within 6 weeks from date. Full stop. The trial court records need not be called for the present.
Grateful, extremely great.
আরেকটা লাইন অ্যাড করে দিয়ে প্রথমে a copy of the plaint of title suit number 135 of 2025 pending before the first court of civil judge junior division at Kandi district Murshidabad, comma, handed over today, comma, be kept on record. Copies of. Thank you. Next. পুরো দুজন মিলে কন্ট্রাক্ট 30 মিনিট চেঞ্জ করতে হবে প্রত্যেকের পাঁচশো তারা দিবে তারা yes sir.
But I am for the appellant.
Right.
The plaintiff in a partition suit, my lord, is agreed by an order refusing to pass an ad interim order of injunction.
Why refused?
Lord, your lordship will kindly come to, my lord, the impugned order. The impugned order contains, my lord, twofold, my lord, reason for refusing. One is that there has been, my lord, the gift and sale of, my lord, the certain properties. It is primarily gift of, my lord, the suit properties in favor of, my lord, some of the defendants by demarcation. So the learned just said that there has been a demarcated transfer in respect of the property.
The original owner transferred.
My client, the plaintiff.
But you are also a co-sharer.
I am also a co-share.
So your share has been transferred.
No, partially.
Oh,
because I am asking for partition in respect of, my lord, 98.5 decimal, which is, my lord, not transferred to the defendants. So that was, my lord, the residue property that I had. Of, my lord, the balance property, what I had inherited, out of that, my lord, I might have not given it to, my lord, other co-sharers, my lord, by demarcating it.
Could you have done that also?
I could not have, my lord. In that way, I could not have.
But you are stopped probably. Yes.
Yes, I do not, my lord, say anything about that, but there has been. And my lord, the other thing is that, my lord, that the learned judge was of the opinion, my lord,
yes,
that because of this reason, my lord, I could not, my lord, get an order of injunction. The other thing was that I could not show, my lord, anything in support of my possession. There were two documents which were given before the learned judge, not the ALR, ROR. The properties are 2 dag numbers only. In 2 dag numbers, my lord, we have inherited, my lord, my client's predecessor, one of the son, and my lord, the defendant is the other son. So, my lord, they both inherited from the father, my lord, these 2 properties in 2 dag numbers. Therefore, my lord, in respect of the property which my predecessor has, my lord, obtained, they have already recorded their names in the ALR, ROR. But that was not also produced before the court by way of a firisti. But the learned judge's contention was that, my lord, I could not show anything to show that I am in possession. These are the two reasons, blood.
What sort of injunction do you want?
Not to raise any construction in the property, not to transfer or alienate, and এক নম্বর বিবাদী যাতে নালিশি সম্পত্তি তৃতীয় পক্ষকে হস্তান্তর করিতে না পারে বা নালিশি সম্পত্তির মধ্যে কোনো কনস্ট্রাকশন করিতে না পারে বা বাদীগণকে নালিশি সম্পত্তি হয়তো উচ্ছেদ বেদখল করিতে না পারে এবং নেচার ক্যারেক্টার পরিবর্তন না করতে পারে।
উচ্ছেদ that probably be possession
because my possession according to Lord, because I am the co-sharer, Lord, my possession is Lord also the possession of the other side. Lord, it is
cannot restrain anybody from
no, Lord, it is.
And what is the third point on due to which Mr. Bardhan has briefed you, Mr.
No, because this client somehow Lord and I can show the photographs, Lord, that which Lord the
photographs.
That is not what it
Interested in photographs. Let us just once see the impugned order.
Lordship, Lord.
There is no caveat in this.
No, there is no caveat. Lord, there is ex parte ad interim that was refused.
Oh, ex parte ad interim.
Lordship.
Possession, yes, we appreciate what the court is.
portions transfer করে থাকে ডিমার্কেট করি জয়েন্টনেস অফ দ্য কত তুমি যে জায়গাটা বলছো ওইটাই ধরেছো ওইটাই পজিশন করা ধরে বডিটা সূত্র দেখে না কথাটা বাদ করে
Well, Mr. Mukherjee, we are granting the admitting and granting the rest of the injunctions apart from possession.
Lordship.
The present challenge has been preferred against an order whereby the learned trial judge refused to grant ad interim injunction on the prayer of the plaintiffs stroke appellants in a partition suit. So next para, the primary premise on which such refusal occurred was that the plaintiffs failed to prove their possession in respect of any particular portion of the property and that the plaintiffs stroke appellants had themselves transferred demarcated portions of their share in the property in favor of some of the defendants. For sub next para, learned senior counsel appearing for the appellants argues that even if demarcated portions were sold, transferred, comma, fact remains that the jointness of the property was not severed merely by such transfer by some of the co-owners. Full stop. Next para, we find from the materials before the learned trial judge, comma, which are also part of our records, comma, that there is no dispute that the learned trial judge did not disbelieve the title of the plaintiff stroke appellants in the suit property, but proceeded primarily on the premise that no exclusive possession in respect of any part of the premises was established by the appellants, and that portion of the appellant's share were sold in demarcated manner in favor of some of the defendants. First of next para, however, comma, learned senior counsel is justified in arguing that even if certain so-called demarcated portions were transferred, comma, the jointness of the property was not severed in the absence of any partition by metes and bounds. Full stop. Next para, as regards possession, comma, the learned trial judge was somewhat justified prima facie, comma, since it is trite law that every co-sharer has right of possession and other legal rights over every inch of the joint property. Full stop. Thus, comma, the appeal ought at least to be heard on the the appeal is required to be heard on the above questions and the other grounds taken in the memorandum. So accordingly, the appeal is admitted. Sub next para, the respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property, and or from changing the nature and character of the suit property till disposal of Can 1 of 2026. Full stop. The appellant shall serve copies of the application and the memorandum of the appeal on the respondents, indicating that the application shall next be listed in the monthly list of October 2026, when an affidavit of service to that effect shall be filed by the appellants. The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date, and prepare and file the requisite number of informal paper books without comparing the records within 6 weeks. Full stop. Next para, the trial court records need not be called for at present.
Lordship.
Thank you.
Great. Agreed.
Yes. Order for situation. Yes, Mr. Pahari.
Your lordship stayed away.
Junior standing counsel is Mr. Bhattacharya, then today also time was short. Another matter. And you have a resolution, Mr. Pahari. This matter won't be hard when you are there. When you are not there, it will definitely be taken up. It appears to be so. Your luck is like that. You and your learned junior's luck. Come back tomorrow, you have a resolution, Mr. Pahari. We will record again. Although the appellant petitioners are represented through counsel, none appears for the state at the time of call. Full stop. In order to enable the state to effectively oppose the matter, the same is adjourned for the day. If on the third occasion they don't come, we may be taking up the matter. Unless there is a further resolution of the bar. Yes.
I cannot go against the resolution.
You can go. Definitely.
Your lordship can go.
It's your choice.
No. Your lordship can go. But we
can go. We don't need have any. We don't require any. But you have a choice of going or not going.
No. I am ready to do it.
Then do it
today.
You want to do?
Lordship, your lordship, today resolution is there. That's why I am.
That is what we are saying. You have an option.
Tomorrow.
32 meter. Both sides are there. We can take.
No,
both sides are not
there.
Both sides are not there.
No,
both sides are not there.
Not only thing. It was fixed tomorrow.
My lord looks at my lord's last order.
My last one.
Yes. He contempt
18.
Oh.
No, very well. Only thing I am
Appear
taking,
tomorrow.
my clients are suffering. Let it retain its position.
Yeah, let it
So it will do nothing to the matter.
Only no.
Nothing should be added on top. That's the thing.
Cannot be. Whatever new motion কোনো নতুন এসছে মেনশনিং হয়েছে যেটা ঢুকবে এর উপরে. No, what happens, some matters the date is given, and if that's of a
No, in our case it is date is given, so it will appear tomorrow.
should not. We don't know. We cannot assure, but
No, but
at best 1 or 2 matters.
only not today.
Yes, only not today.
It will automatically appear tomorrow. Bachao like this.
Item number 33.
Same, not থাকলে বলছে. Oh, you're there.
Yes, sir.
What about the other side? Will you do them at 2? We're just making up.
34.
My lord, I am on the behalf of respondent.
Respondent.
Yes, fine.
Which for the petitioner? You are for the petitioner.
For the respondent.
I'm for the petitioner, Lordship.
You are for the petitioner.
Yes, Lordship.
Sorry.
No, it's fine. Yes. Yes, move the matter.
Yes.
Need not run. Respondent is waiting for you. Respondents are waiting for you.
Hello.
Please take your seat, sir. Yes.
My lord.
You also take a seat. Yes. Affidavit, sir.
My lord, actually, I am the petitioner respondent number 5 here.
State is not represented.
State representative.
You are for the private. You are for the state.
No, yes, my lord.
You are for the state.
Yes, my
Very
lord.
good. Fine. Please.
My lord.
And you are for the private respondent.
I am
All sides.
I am for the I am the respondent petitioner. Respondent number 5. Actually, a land was occupied by them for the 19 years without paying any rent. I submit an application before the Calcutta Thika controller, and Calcutta Thika controller on by Baro
Thika controller, not
Calcutta Thika controller.
Achha,
West
you have
Bengal.
given the name of the act as 97 Act, Premises Tenancy Act 97.
Actually, the Thika Control Act. It should come.
Swapon Kumar Khaskel.
হ্যাঁ স্বপন কুমার খাসকেল কত লিখেছে
Yeah, in the A form as well as this, in the classification you have given 97.
Premises tenancy, partly premises tenancy. is it?
So let us hear you, yes.
Yes.
So you approach the Tika controller.
I approach the Tika controller.
Who are you? You are the Tika tenant.
No, I am a Tika tenant and they are the Tika Bharatia.
Very good.
The Tika controller, after hearing the matter, that for the 19 years, they are not paying any rent. They have purchased a property and living there.
Tika tenancy একটা দিন আর premises tenancy একটা দিন, দুটোই লাগে।
They have purchased a property and already living there, but keeping my room there in their
So
occupation.
did you ask for eviction?
I am for evictions. They challenge this order. They file an original application before the land
What was the
tribunal.
order? Eviction order was passed.
No, the land tribunal for the last 3 occasions, they kept the matter pending.
What matter was paid? What went before the tribunal? What was the initial order by the
After passing the order of the Calcutta Tika controller.
Tika controller passed what order?
The order for eviction.
That
For
is what you
eviction,
asked
that
to
was
pass an eviction order.
that was challenged by them before the land tribunal. Tribunal in the 3 occasions did not heard the matter. They have filed stay applications as well as
Tenancy একটা দিন। আচ্ছা।
stay application. I filed objection both of the original application as well as of the stay applications.
এগুলো রেখে দিন। It's their challenge before the tribunal. It's pending.
It is pending.
So what do you want now?
Now this speedy disposal on that day, my lord, either expeditiously.
Say that. Only that.
9th of October is the next date.
9th
Yes.
of October.
I'm in suffering, my lord.
No, we understand. What is the stage of that?
Stage nothing. They are giving me dates, adjournment. They are taking
So
adjournment.
is there any scope of evidence there, or
No.
they have filed their objection? Oh, you have filed your objection?
I already filed objections. My lord.
She's ready for hearing.
Ready for hearing.
Yes. What do you say? You first. We are directing the matter to be disposed of within a limited period.
Your Honor, we do not have any kind of objection.
And state has a neutral role here.
The petitioner has come up before this honorable court challenging the order dated 30th June 2026 passed by the West Bengal Land Reforms and Tenancy Tribunal, by which the Learned Tribunal has fixed the matter on 9th of October 2026 after adjourning the matter several times. The petitioner seeks expeditious disposal of the original application being OA 2775 of 2025 LRTT.
Along with
What is the MA?
Along with the stay application. That is
Along with MA 1474 of 2025. Paragraph considering the submissions advanced by the parties. Considering the submissions made by the parties, we request the Learned Tribunal to dispose of the original application as well as the connected miscellaneous application within a period of 3 months from the next date without granting any unnecessary adjournment to the parties.
It would be better if it is possible on that date. They already fixed
Cannot be
it.
disposed of on that date. Within 3 months from that date. By positively picking up the matter on the next date.
Yes. After taking up the matter positively on the next date.
Yes, ma'am.
WPLRT 144 of 2026 is disposed of.
Grateful, my lord.
No arrest cost.
No arrest costs.
Thanks. Perfect. On the একটা ঢুকিয়ে দিয়ে affidavit size try to be kept.
Affidavit size.
Item number 35, man, appearing for the petitioner in this matter. This is affidavit of service, man.
Bring the state, Mr. Chaudhary. Either stop the rain or bring the state.
The state is not here, man.
Affidavit of service filed today be kept on record. Full stop. None appears for the state at the time of call. Let them understand adjourn for the day.
But I'm appealing for the state.
Lordship, I am appearing for the petitioner but praying for not today.
State is appearing, you have got a rare opportunity where the state is appearing and you are losing that. What is the matter about? Start the matter. For adjournment, you have to start the matter. Either of you start the matter. Your choice. Give us the bare facts at least. What is the matter about? Under which act? How long are you practicing?
Lordship, the brief is not with me. Actually,
How long are you practicing?
uh, Lordship, I'm
How long are you practicing?
6 years. Lordship,
6 years sufficient, yes. Start it.
brief नहीं है. Word खाता तो
We're not trying to shame you. We're trying to ascertain whether you are capable of starting. You are, because you're practicing for 6 years. Starting.
Lordship, I'm just downloading the brief.
I'll take our brief and start arguments. Please take your seat, yes.
In the round.
नहीं है.
You're afraid of hard copies. You have the hard copy before you. Start with that. Start the matter. Start the matter. What is the matter about? Under which act?
Lord. Lordship, we have challenged the order passed by tribunal.
Yes. There was a previous decree of a suit.
Lordship, there is.
What are you wanting here before the tribunal? It was your application or their application?
It's our application. Lordship.
What relief did you ask for?
Lordship, can it be 10 minutes pass over, Lordship?
Yes, yes, absolutely. 10 minutes possible. Fine.
Grateful, Lordship.
Thank you. Fair enough. You keep that, prepare yourself.
Yes.
You can keep this file. You download a soft copy. You can keep the file. You sit here just. Don't go outside the courtroom with the file. Yes. Call on the next. Please stay back. I will
Lord,
take
I'm
it up.
also preparing in this.
My lord,
Yes. Yes,
in this
Mr.
matter,
March.
my lord, I beg to appear on behalf of the petitioner.
Now rules have changed.
My lord, yes, rules have changed.
No,
My lord,
rules.
rules. My lord,
Rules are the same. Yes.
my lord, there is a private respondent I have served.
Good service.
Good service.
Today, should you take it up?
My lord,
We don't know what is the. I mean, is it innocuous against the private respondent or it substantively hits them?
my lord, this is the case, my lord. Actually the action of the BLRO is under challenge.
But they'll be affected. Acha, open the case, Mr. Mathur.
Yes,
since
my
you are
lord.
here. Yes.
My lord, this is the plot, my lord. 3 plots. 3 plots are involved in this case. These plots are the plot number 20. I have stated in paragraph 3. Plots number 26, 339 and 340, measuring about 199, near about 2 acres of land.
Yes.
These are the vested land of the government, and
at the disposal of the government. Originally, the private respondent number 8 came before this honorable court for settlement of the land in his favor. Respondent number 6 in his favor. This honorable court directed the BLRO to consider the case and pass an order.
Apparently, from the impugned order, it appears that you sought for a contempt. I mean, your defense in a contempt was that you are not
my lord,
heard.
my lord, I am coming, my lord, that because here in this case, my lord, the my lord, in compliance with the order of this honorable court, this BLRO passed the order. BLRO hold that this land, the proposal has been settlement in favor of the present petitioner, and his prayer was turned down. Patta have been issued in favor of the petitioners. Their names have been recorded in the record of rights. Thereafter, a challenge was made before the tribunal, and in the tribunal specifically held that these 16 and 17 decimals of land is in favor of the petitioner. It has already been settled. Patta has been granted, and the private respondent only 16 decimals of land. Now, after a lapse of record of rights was also prepared in the name of the petitioners. Thereafter, my lord, suddenly the name of the petitioners have been eloped in the record of rights. They came forward before the tribunal. The tribunal passed the usual order, considered the representation. That representation was not considered, contempt. Now, in contempt, my lord, the BLRO has passed certain orders denying BLRO has submitted a report denying everything. The RS record wherein Patta has been given are not readily available, denying everything, and my lord, only they have recorded that the name of the private respondent has been recorded. And the tribunal, in a contempt proceeding, held that in our limited jurisdiction go again to the appellate authority.
But if he has decided on merits, Mr. Mahato, is the tribunal incorrect in saying that?
My lord,
in contempt,
my lord, when admitted fact is that the
good, bad, indifferent, that's a legal error or a patent perversity even maybe. But
Perversity,
even patent perversity, we understand it's your argument is patent perversity.
Patent perversity.
Whatever was done, he has undone.
My lord,
we appreciate that, but a challenge on merits has to be preferred. Tribunal, we cannot set aside this order saying that this is wrong. In contempt, we also don't do that.
my lord, again tribunal, again, my lord, appellate authority
has to be,
my lord, because my lord, the
and it will be open to you to ask for costs also from the appellate authority as well as the tribunal.
if your lordship kindly, my lord, the documents, the pattas are there, case are there.
The tribunal could not go into the merits, Mr. Mahato. Something had to be looked into the document.
The tribunal could have called for the record from the BLR.
It's not contempt. Direction was given, he has decided one way or the other.
On the basis of the report, what is the report? That is contrary to the records. He has tribunal has disposed of the matter on the ground of
contrary to
limited
records. Is that contempt? Does that amount to contempt, Mr.
but again, my lord, tribunal ought to have, my lord, if it is not contempt, my lord, ought to have decided the matter by the tribunal calling for the records.
Could not have so want to done it unless there is a challenge under section 10.
My lord,
tribunal directly also could not do it because the appellate authority comes.
My lord, tribunal directly not go to the appellate authority. My lord, I am agree on that. My lord, again we have to, my lord, recycle.
We have to. What can be done, Mr.
My lord, we can approach with the tribunal again.
How can you? There is an appellate authority.
My lord, then my lord, what has been settled in 1997, 2000, my lord, 18, record of rights are there, pattas are there, everything will be nullified. And we are again to go, my lord, recycle.
We have to enter into the merits of the BLRO's decision, because the BLRO said, BLRO denied the existence of those.
Yes.
But
yes.
Those have to be seen then by the tribunal.
Yes, that
could only be done by an appellate authority, not by the tribunal.
My lord, BLRO said denied everything. My lord, if your lordship kindly see the report, I have annexed the report. My lord, report that has been, my lord, is submitted by the. My lord, page 80.
Yes, order has been quoted. The order has quoted the BLRO.
Yes, my lord, if your lordship kindly come page 87 and 88, this copy was supplied to the petitioner. May I place this note?
Yes.
Case of card is put up, issued notice fixing the date on such and such. CR is put up today, service file properly. Gone through the case records, it appears that as per LR records, Janmenjoy Mondal and Jagabandhu Mondal, both sons of Jotin Mondal got Patta RS case number 1 such and such, corresponding to LR plot number 42, 574 and area of 17 and 16 decimal respectively. This is the admission. And my lord, then my lord, he said only 3 decimals. And proposal would be taken for annulment of
No, in
contract.
contempt, tribunal could not go into this. So you had to prefer a challenge.
Well, this is the denial. Now only 3 decimals. He is finding only 3 decimals, and my lord, admission is that my lord, the in Patta case we have given 16 and 17.
Some reasons have been given that those may be bad, but prefer a challenge.
But then, my lord, we have to recycle again. But the Patta which is, my lord, settled in my favor.
Law contemplates a recycle. The present challenge has been preferred against an order whereby the learned tribunal dropped a contempt proceeding on the ground that since the alleged contemners took BL and LRO, in pursuance of a previous direction of the tribunal, has passed a reasoned order, the appropriate authority would be to go before the appellate authority under the statute, and it was beyond the limited contempt jurisdiction to go into the merits of the main matter. So next counsel for the petitioner submits that the BL and LRO, although paid lip service to the direction of the tribunal, upset the entire settled position as established by the relevant documents and records by way of the so-called reasoned order. First up, it is submitted that in the event the petitioner is compelled to go back to the appellate authority and undertake the entire cycle of challenge before the appellate authority first and then the tribunal, it would be a travesty of justice in view of the perversity writ large over the order of the BL and LRO. Next para, however, on a careful perusal of the order of the BL and LRO, which is also annexed here too, we find that some reasons have been attributed for passing the said order. Next para, even if the court is to come to a conclusion ultimately that the said order is dehorsed the law and the records, the court has to undertake an exercise of examining the records as well as the other relevant documents which led to the findings of the BL and LRO. Such exercise, as rightly held by the tribunal, was entirely beyond the limited contempt jurisdiction. The remedy of the writ petitioners lie in an appeal before the appropriate appellate authority under the relevant statute against the said order of the BL and LRO and not in a contempt proceeding. Since the BL and LRO has passed a reasoned order, whatever may be its legal worth, the recourse lies in an appeal and not in a contempt application. Accordingly, we do not find any infirmity in the impugned order of the learned tribunal. Hence, WPLRT 148 of 2026 is dismissed, thereby affirming the order dated February 6, 2026, passed in MA 530 of 2024, arising out of OA 2413 of 2021, bracket LRTT, granting liberty to the writ petitioners to prefer an appropriate challenge against the order of the tribunal, the order of the BL and LRO. Dated, what is the date of that order?
My lord, it is 21st. My lord,
6th February 2026.
6th February, thank you.
My lord, that is the order of the tribunal. My lord, the report is BLR order.
BLR
29th December 2025.
Dated December 29. No, that was a notice.
No, my lord, that is the compliance report. 29th
29 December.
29 December 2025.
December 29, 2025. Full stop. No rest to cause suggestion. প্রথমে affidavit size shall to keep. Thank you. Thank you.
নেক্সট মেথডটা তো তুই টাইমলি করবি
Ready হয়েছে? Ready? বস। বস। You just check the password matter and then call it. Yes. Yes. What is that?
So land is originally belonged to the deity, and for some reason the petitioner have to file a title suit being 151 of 1995, which was decided in presence of the state party, whereby the land was settled in favor of the petitioner petitioner therein.
Petitioners in the capacity of Shevites.
Yes. So, on that basis, the petitioner tried to mutate their name in record of right, and for that reason, they made an application before the BLRO office. That was not considered. By by challenging that order, they preferred that original application, which was again decided in against the petitioner in in certain grounds, which is not at all maintainable, lordship. First of all, the suit was decided in favor of the petitioner when there was state was the party. So obviously there was and state did not prefer any appeal against that suit. So obviously it was settled law, and the order passed by the learned court was reached its finality. So the question of again tracing that issue before the BLRO office, that not at all maintainable, and decision was taken by the court. So obviously the quasi judicial body has not power to decide whether that suit is maintainable or not. And in the impugn order, lordship.
You sought for a mutation on the strength of the civil court's decree.
Yes, lordship.
The civil, what decree? Have you got a copy of the judgment or decree passed in the civil court? Have you annexed that?
Yes.
Where is that? Here's the page number. It should be annexed here. That is the strength of your
yes
mutation application.
This is 47 to 56, lordship. Uh, 56 last para, relevant portion.
So the title of the DT was declared and injunction was also
Yes,
granted.
yes. And on that basis, I have preferred.
Let us see the order of the BLLRO now.
The next page is BLRO order.
Page 57.
58.
No, start from 57.
Right, it is start from 57. The relevant portion is 58.
No, let us see the entire order, please.
Lordship, I will place.
Yes, yes.
Yes. On 18th 5 2017.
Forget that. Next one.
Okay.
2nd June.
Second,
Not okay, not okay. Yes, yes,
Yes, Lordship.
yes.
The concerned DA put up the case record today for hearing and disposal. Sri Kanai Chandra Patra, Devidas Mahapatra and others have appeared today and filed Hajira. Heard all of them separately. The learned civil judge, Junior Division, Second Court, Bankura, by his judgment on 28 June 2002 passed an order that Lordship, I am a Mukaddamati
We have read that. We have read that. Skip that. Read the English portion.
It is clear from the RS Khatian being number 480 of Mauja, Tetul Muri GL number 138 that the said Khatian was an intermediary Khatian and valid up to 31st December 1361 BS and plot number 16 1972 measuring area 1.25 acre was in the said Khatian and was vested to the state due to non-submission of B auction form within 30 April 1958 and the said plot is recorded in the LR Khatian number 1. It is stated that second page of the judgment of title suit 151 of 1955 that the Sebayat of the said deity had submitted the B option form through the registered post to the BLRO on the and SDLRO Bakura on 10/7/1995. It is also stated in the page number 5 of the said judgment that learned advocate of the applicants mentioned that a return in form B can be amended or revised and intermediary is entitled to file a fresh return in the form B. In this respect, we can mention that a single bench of Calcutta High Court has held that on a proper construction of section 6(1) of 6 subsection 1 of the Act and Rule 4A of the West Bengal Estate Acquisition Rules 1954, it cannot be held that there was no scope for submitting a second B option form under any plea. Plea. It cannot be the intention of the legislature that once a B form has been submitted by an intermediary, it cannot be altered or amended under any circumstances, even though it may lead to injustice. It has further been observed that it would be unjust if a person having made a bona fide mistake in B option form is not allowed to amend the same when he claims to retain the land within the prescribed ceiling and particularly when there is no dispute that the character of the land had not been correctly shown earlier and that the intermediary has a right to amend the B form already submitted by filing a fresh B form within a reasonable time from the detection of the mistake. It is also stated that the Honorable Judge of the Honorable High Court, Calcutta, by his judgment in WPLRT 169 of 2011 on 30th August 2011, Section 57B, debarring initiating of suit, assailing order of vesting and passing of a decree cancelling vesting order. In view of such statutory embargo, the order of the learned tribunal is modified in this extent that the concerned revenue officer will dispose of the representation in accordance with the law upon taking note of the statutory embargo of filing civil suit under Section 57B of the West Bengal Estate Acquisition Act and enforceability of any decree in view of the said prohibitory provision taking away of the jurisdiction of civil court. The undersigned also take the reference from the judgment of the Honorable Supreme Court of India in Civil Appeal number 7209 to 7210 of 2015 in the name of Bengal Ambuja Housing Development Limited versus Pramila Sanpui and others, that the appeals of the appellant housing board are allowed by holding that ex parte in interim order of temporary injunction passed on 16th of June 2006 by the learned subordinate Judge Alipur in the title suit number 121 of 1962 in respect of the property in question purchased from the legal heirs of the late Gangadas Pal, who was declared as intermediaries under Section 6 of the Act 1953, and therefore the same are not binding on the appellant as it is not party to the proceeding
and the civil court did not have the jurisdiction to deal with the said property. As per section 57B2, subsection 2, clause A, B, C of the West Bengal State Acquisition Act of 1953. On considering the above, the undersigned officer disallowed the application for correction of RS, ROR as well as LR, ROR as per orders of title suit 151 of 1955. Thus, the case is disposed of.
You prefer a challenge before the tribunal. Tribunal head, it does not have jurisdiction.
Yes, Lord.
In view of L. Chandra Kumar and all. So then you preferred an appeal.
Yes, Lord.
Where is that appeal? Appellate order.
After by challenging this order, I have came before the tribunal, Lordship.
We saw the tribunal held it does not have jurisdiction and dismissed. Your order challenge, the order of the tribunal starts at page 59 and ends at page 67.
Yes, Lordship.
67, tribunal says, discusses every other judgment, previous judgment, and holds 10(3), Tribunal Act, no jurisdiction, so therefore dismissed.
Yes, Lordship.
So then you preferred a challenge against that or preferred a challenge against the BLR order to the appellate authority?
No, I am coming before your Lordship by challenging this order.
No, this order was challenged before the tribunal. Dismissed.
Against that minute they have come.
Yes,
Against this you have come. Tribunal was justified. You have to go before the appellate forum.
Lordship, there is
Yes.
There is several law points. That's why we have come before your Lordship.
One law point is clear that whether if it's without jurisdiction totally the tribunal can interfere.
Yes, Lordship.
Because virtually nullified the civil court's decree.
And the second one is the question of filing B option form does not arise at all as the ceiling limit is very less.
Who is appearing for the private respondent?
Only state is party, Lordship, no private.
No private. What is
No.
your stand, sir?
Lord, this is the tribunal has rightly said that this is an appellable order. They should prefer an appeal against this order.
Understood. But if there's a palpable jurisdiction at the end of the day, tribunal is exercising the power of the which was exercised by the High Court under 226. Virtually the similar power. See, it's palpably without jurisdiction.
Look, but 57B2 is a barred blood.
Yes, 57B2, let us see. 57B2.
Because the suit, Lord, in the suit, the learned judge has decided the vesting order, whether vesting order is bad or not.
No, that is the difficulty. It is not the vesting order which has been done, the frame of the suit is different. The title has been, the title declaration has been sought.
Yes.
It has been declared that the property belongs to the DT.
But that point is pending before the special bench, Lord, of this court, Lord, whether the suit decree is binding or not.
Till the special bench is heard, I mean, we cannot wait till that.
Lordship, your Lordship has given a order. Where is?
Give your learned friend a copy of that. Unreported order, he is not supposed to know.
It is order passed by your Lordship.
I passed, I understand. I am very happy about that. But they have to have a copy of that.
Yes, Lordship.
Otherwise, unreported judgments, if you don't give copies, they're not supposed to know. Give to your learned friend one copy. We have an extra copy.
He, as per. As per your Lordship order, if title suit, if
title declaration any matter in respect of which authority under this statute has jurisdiction set apart. Title declaration. Is the way. What was the premise of your suit? What was the basis of your suit? You claim title on the basis of what?
They did not file B form. That's why the land in question was based.
Later on, we have filed, but the
Subsequently, they filed.
question of filing of B form does not
Because
arise at all
basically at that
because
they did
our
not file.
ceiling limit is very
Was
limited.
based it, and they
But
have
they filed this B
Yes.
form filing was after the decree.
yes. Not your lordship.
But B form filing, I mean, in certain cases, B form filing is not necessary even. If it's vesting statutorily, it's vested.
Below the ceiling, it is not necessary.
Not necessary.
It is below the ceiling limit.
1.25 acres. That I
Exactly, because that is the law. So you know the law because the language is such. If it is above ceiling limit, then the question of
Yes.
those things come.
Only the 57B2 is the law coming into the.
Then we are.
Not kindly come to page 55. Not your lordship will see that the learned judge has said that এর কোনো কাগজপত্র দাখিল করিতে পারিনি বা বাদীরা যে বিফর্ম দাখিল করেছেন সে বিষয়ে কোনো রেকর্ড অফিসে নেই সুতরাং বিবাদী সিএস রেকর্ড দেখাননি 10 to proceedings এর কোনো ডকুমেন্ট দাখিল করেননি এবং বাদী এক্সিবিট C4 হিসাবে বিফর্মের কপি দাখিল করিয়েছেন তাহার বিরুদ্ধে বিবাদী কোনো সাক্ষী দেননি যে বিফর্ম দেয়নি মানে দিস হ্যাজ বিন ডিসকাসড
No, till the possession is taken of the property, the reform can be filed.
No, yes.
There are judgments. There are judgments. Till the possession is taken by you, the state, they can file B form. That question is left open. In fact, as per the language also, you know it.
7B2, Lord, your lordship will see. B2B, no dispute involving determination of the question, either expressly or by implication, whether a riot or intermediary is or is not entitled to retain under the provisions of this act such land or estate or right in such estate as the case may be.
But the question of retention comes only if it's beyond the ceiling limit.
Beyond the ceiling.
If it's below the ceiling limit, the retention, this question does not arise. This is the question which does not arise. Is it an admitted position that in this case it was below the ceiling limit?
Yes, 1.25.
1 point.
Yes, Lord.
What is your full name? Your
Nandini Sharma.
Ms. Nandini Sharma, appearing for the writ petitioner, argues that the learned tribunal erred in law in refusing to exercise jurisdiction in a challenge against a palpably vitiated and perverse order of the concerned BL and Niraro, thereby reopening the decree passed by a competent civil court. First up, it is argued that the learned tribunal, in the impute judgment, proceeded on the basis that it did not have jurisdiction, since there was a provision for appeal under the law against the order of the BL and LRO. First up, however, it is contended that if the order is palpably tainted by jurisdictional error, this is on what proposition that B form can be filed before legal possession is taken?
No, Lordship. It is in respect of the if the title, if the civil court has decided the point.
Very well, yes, very good. Is error, the tribunal.
Para 7 and 8, Lordship.
Very,
I'm relying
yes, we have seen para 7. The tribunal can set aside the same. Full stop. Next para, learned counsel takes the court through the judgment and decree passed in a civil suit where the state and the BL and LRO both were defendants. Which of the said suit was decreed in favor of the deity, of which the present petitioners are Shebites, by declaring the title of the deity and restraining the defendants from disturbing the title and possession of the deity in respect of the subject property. Full stop. Next para, As such, comma, the BL and LRO, comma, while holding that the said decree was was bad in law, comma, in view of the bar under section 57 capital B of the West Bengal Estates Acquisition Act 1953, comma, the same was a patent jurisdictional error, comma, since the conclusive decree passed by a civil court cannot be reopened by a BL and LRO. Push up next para, even otherwise, comma, it is contended that the subject property being below the ceiling limit as stipulated under the 1953 Act, comma, the question of retention did not arise at all. And as such, comma, the bar under section 57 capital B within bracket 2 is not applicable. Push up next para, learned counsel appearing for the state submits that in the present case, comma, B form was filed but much beyond the statutory time limit. Push up as such, comma, it is argued that the BL and LRO was justified in observing that the bar under section 57 capital B of the 1953 Act was applicable, comma, as the question revolved around whether a riot or an intermediary is or is not entitled to retain under the provisions of the Act. Push up next para, even otherwise, comma, learned counsel submits that the tribunal rightly pointed out that since there is a provision of statutory appeal, comma, the same cannot be bypassed by usurping the jurisdiction of the appellate authority by the tribunal. Push up next para, upon a comprehensive perusal of the materials before us, comma, we find substance in the contention of the writ petitioners. Push up next para, the BL and LRO, comma, in its order dated June 2, 2017, comma, came to the arrived at the finding that the decree of came to a finding that in view of the bar under section 57 capital B of the 1953 Act, comma, debarring initiation of a suit assailing an order of vesting, comma, the decree passed in the civil suit was without jurisdiction, comma, thereby virtually nullifying the decree of the civil court. Push up next para, however, comma, as held in a coordinate judgment in WPLRT 71 of 2026 within bracket Probir Kumar Ghosh alias Probir Ghosh and others versus the state of West Bengal and others, comma, cited by the writ petitioners, comma, if a civil court has already declared the right, title and interest of the writ petitioners in respect of the subject plot, comma, the tribunal would be without jurisdiction in dismissing the original application, even if the private respondents are in occupation of the said plot forcibly, comma, which possession would then prima facie be unlawful. Push up next para. Although no detailed proposition was laid down in the said judgment, comma, even independently, comma, we find from the tenor of the civil court's decree in the present case, comma, which was passed in title suit number 151 of 1995, comma, that the relief sought before the civil court was principally declaration of title of the suit property, and the permanent injunction and the relief of permanent injunction was merely consequential thereto. Full stop. It is only the civil court which is vested with the jurisdiction of declaring the title of a person or entity in a property. Full stop. Within the four corners of the 1953 Act, comma, there is no authority which is clothed with such power. Full stop. Thus, comma, the civil court, comma, while passing the decree in the present case, comma, was exercising its exclusive domain as contemplated under section 9 of the Code of Civil Procedure. Full stop. Next para. Hence, comma, it cannot be said that the bar under section 57 capital B within bracket 2 was operative. Full stop. The civil court was not deciding a question whether a riot or an intermediary is entitled to retain under the provisions of the 1953 Act, but independently declaring the title of to the property. Full stop. Next para, secondly, comma, in view of the admitted position that the subject property was below the ceiling limit, comma, the vesting there was no vesting at all under the provisions of the 1953 Act, comma, thereby rendering academic the question of retention of any land. Full stop. The question of retention under section 6 of the 1953 Act arises only in cases where the land is above the ceiling limit. Full stop. If the land is within such limit, comma, there is no question of retention or entitlement thereto. Full stop. Thus, comma, the bar under section 57 capital B within bracket 2 within bracket small b, which provides that no civil court shall entertain any suit or application where a dispute involving determination of the question whether a riot or an intermediary is or is not entitled to retain under the provisions of the Act, comma, is not attracted at all. Full stop. Hence, comma, the BL and LRO committed a patent and palpable jurisdictional error in reopening the decree of the civil court, as well as in holding that the bar under section 57B of the 1953 Act was applicable at all. Full stop. Next para, it cannot be lost sight of that under the provisions of section 10 read with section 6 of the West Bengal Land Reforms and Tenancy Tribunal Act 1997, comma, the tribunal is closed with powers akin to the jurisdiction of this court under articles 226 and 227 of the Constitution of India. Full stop. Next para, in fact, comma, even the virus of statutes apart from parent statutes which of the specified acts are also amenable to challenge before the tribunal under section 6 of the said act. Full stop. Thus, comma, it was well within the jurisdiction of the tribunal to set aside the order of the BL and LRO, which was tainted by patent jurisdictional error. Full stop. In such view of the matter, comma, this court is of the opinion that the impugned order of the tribunal as well as that of the BL and LRO cannot be sustained. Full stop. Accordingly, WP LRT 146 of 2026 is allowed on contest, comma, thereby setting aside the impugned judgment dated December 12 and November 12, 2025, passed by the fourth bench, West Bengal Land Reforms and Tenancy Tribunal in OA 2388 of 2017, bracket LRTT, as well as the order dated, order number 2 dated June 2, 2017, passed by the revenue officer, comma, that is the BL and LRO. Which BL LRO? Bakura?
Onda.
Huh?
Onda.
Onda, comma, yes, Onda, comma, district Bakura, in case number 192 of 2017. Full stop. Next para, you sought for a mutation on the strength of that civil.
Yes, Lord.
The said BLLRO, that is respondent number, which respondent?
3.
3 is hereby directed to correct the records of right and mutate the names of the subject property in the name. But you have filed in your independent capacity this writ petition. You are acting as Shevites of the DT.
Yes, Lord.
Then this Gossetly is bad. In the name of the DT Sri Sri Durga Thakurani, comma, represented by the present writ petitioners as Shevites, as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order, to the BL and LRO. No address to cost, urgent certificate. প্রথমেই করে দাও, affidavit size file to be kept on record. Leave is granted to the learned advocate on record for the petitioners to carry out the necessary corrections in the cause title of the writ petition to reflect the writ petitioners to represent in the representative capacity of the DT Sri Sri Durga Thakurani. You just write above this Sri Sri Durga Thakurani represented by Shevais and then do it right now. Very well argued. Next. Correction to করে দেবেন এখন. Who is the advocate and you are the advocate on record? You do it right now. And say write amended with the leave of court. You know that. Next.
Yes. Appealing for the private respondent. 5B and 70.
Petitioner.
My learned friend is appealing for that.
Everybody is the state will appoint you as amicus curiae for the state.
Yes.
You have once caught hold of
He is
one of the advocates of the state and we are not leaving you. But he has to then have a state has a role to play or state's role is
yes, obviously.
Should we take it up today or
Let it be take it up tomorrow. It a big matter. It will take time.
Big matter. There are
46 46 pages of judgment of the trial.
Yesterday,
we can take it up next year also.
For certain internal protection is needed.
Tomorrow, this weather is situated this
Then you
time
are not
of that.
appointing as amicus curiae. Please inform your office that somebody should be engaged. Since the state remains unrepresented, although the writ petitioner and the private respondents are represented through counsel, the matter stand adjourned for the day. Affidavit service file today be kept on record.
And Mr. Seal is appointed as
So we are not appointing because he is in difficulty tomorrow and day after. If by chance it is taken up day after tomorrow, then somebody else may be there. So he'll be in embarrassment then.
so that this person is fit person.
No, he's fair and we know that. It's not about him. If somebody else has been engaged and he comes tomorrow or day after tomorrow, that will be an embarrassment for him.
Oh, আজকে proxy নাকি? Today he is proxy.
This is a particular land matter.
No, him and Mr. Nilanjan Bhattacharya, these are the main people who are assigned to this court right now. Next.
তাহলে কালকে হবে না?
We're just adjourning for the day. Just is a Bhaskaman ki record আছে?
হ্যাঁ, মান্নাই যে একবার
Record আছে? We are not this week. Definitely, we'll keep it in the month of September. In view of the sad demise of the learned advocate on record for the petitioner, let the matter stand adjourned and be listed next in the monthly list of September 2026 in order to enable the petitioners to make alternative arrangements. Mr. Shil, can you just ensure that we are directing the state to give a notice to the writ petitioners directly? The state shall inform about the demise of the learned advocate for the writ petitioners to the writ petitioners in writing in the meantime and file a receipt in that regard on the returnable date. Please take that trouble.
My lord, I'm for the state. My lord, I'm being led by Mr. Nikunj Berlia in the matter.
Understood, but nobody is appealing for the petitioner. So we are just making not today.
He stated.
Not today. Tell him not today. Yes.
State.
Yes, Mr. Mondu. Respondent, Mondu. So then not today only, Mr. Mondu.
Okay.
Both sides?
43, no, 42.
Mismatch. You're in 42, he's in 43.
But so far 41, 42 is concerned.
No, keep it with you. We'll take it up on the next day. Today you have a resolution, nobody's there. Not today only.
Lordship. Yes. 43 is same.
What is same?
Not good.
Same. Not. Any matter, both sides are there. Your other side is not there. Both sides are there, any matter?
Only this court is running, my lord. Other one, there is no court.
Others have run away. Like both sides are not there. Well, today we have ourselves seen.
Yes.
I was also late actually.
Yes.
Well,
I
and
was-
brother came in time. I was personally late.
Today. I don't buy how I shall go to my house.
Yes.
That's so cool because
That's the greater problem
That's a
for
greater
all of us.
Yes.
You're a good swimmer. What is the problem? So there's a comment to make.
Yes, no?
You're a good swimmer. You're a good swimmer.
Oh.
You're actually a good swimmer. Underwater or in deep water? Deep water. Huh? Go with your
Deep water.
Item number 46, Mala, I have some difficulty tomorrow. Mala.
Tomorrow probably we'll be taking up those specially assigned matters
Yes.
first. So, in any event, we won't be reaching. If we reach, just keep somebody with us.
Today meeting will be at 1:25 for Bhaskar Marna.
Oh, that has been postponed
That
for the
has been
rains.
postponed, yes. Today it has been postponed.
125 means 3.
I think 3:30. 3:30.
Sorry, 3:30. Yes.
Yes.